Good afternoon. This meeting will come to order. It's a public meeting of the Commodity Futures Trading Commission to consider issuance of the following proposed rulemakings: the Dodd-Frank Wall Street Reform and Consumer Protection Act. We thank you, Sarah and Ananda, for coming up. There's 6 or 7 proposed rules that staff are going to discuss with us. One related to foreign boards of trade, another the registration of swap dealers and major swap participants, a third with regard to new whistleblower provisions in the Commodities and Exchange Act, and then a set of rules, which I gather Sarah and Ananda will stay in the seat for a while, on these, I guess there's 4 of them all told that we'll hear from the staff on: risk management policies of swap dealers and major swap participants, 2 related rules concerning firewalls and conflict of interest policies, and also the designation of chief compliance officers and related compliance policies of swap dealers, major swap participants, and futures commission merchants. I'd like to start by thanking all of the staff and Commissioners Mike Dunn, Jill Summers, Bart Chilton, and Scott O'Malley for all their thoughtful work to implement Dodd-Frank. As the public is probably watching us in progress, there's a lot that we're working on, so it's really only because of everybody's collective efforts that we're getting this through the Commission. I'd also like to welcome the public and market participants to this meeting, and welcome not only those listening on the phone and watching live on the webcast, but of course your public comments are going to be very important to us, because these, even if we do move forward today and vote some of these out, they're just proposals, and we really do encourage the public to give us comments on these. This is our 4th public meeting. I think anticipating what may happen today, and I'm not going to do this every meeting, but I will do it again because you'll correct my math. But I think we will be up to 18 proposals, 2 final rules, and 3 advance notices of proposed rulemakings. We do have one more public meeting scheduled so far in November. I think it's the 19th, and we're looking to calendar, I think, 3 meetings in December. I think one of them may have been already in the Federal Register, but we'll, as we get the other 2 dates, we'll put them in the Federal Register and announce the topics for the 19th of November. We'll announce those topics, I think, by this Friday. We're human. Some of this will probably slip to January. We'll find out. Maybe there'll be a date or 2 in January and so forth. I anticipate that one thing I wanted to talk about is I anticipate that we will be taking up in our December meetings 2 important joint proposed rulemakings. These are the 2 joint rulemakings on definitions. One is on entity definitions. One is on product definitions. The Dodd-Frank Act requires the CFTC to write these jointly with the Securities and Exchange Commission. And these proposals, when we get to them and get them out, are important in their own right, but they're also important as they allow the public to consider what we're doing, like today. But those rules will be out there maybe a couple or a few weeks after these, but they'll be running concurrently. And as the public sees those specific definitions on entities and so forth, I think that will help inform even what they're doing on rules today. So with that, I'm really going to turn to my fellow commissioners to see if they have some opening comments. Commissioner Dunn.
Thank you, Mr. Chairman, and thank all of you for joining us today in this important meeting regarding the implementation of the Dodd-Frank Act. Today's meeting will address proposed rules regarding the registration of foreign boards of trade, implementation of new whistleblower provisions, the registration of swap dealers and major swap participants, and business conduct standards for various registrants. I will support the publishing of these proposed rules in their current form, but I have yet to decide how I will vote on any final rules. I will make those important decisions only after I have had a chance to carefully review all the comments that the agency receives from the public and get final recommendations from our staff. I am especially interested in the proposed rule to register foreign boards of trade. I have long advocated that the Commission codify this procedure for recognizing foreign boards of trades. I believe that eliminating the current no-action process and adopting a registration regime will provide legal certainty, transparency, and fairness in this area. It is somewhat discerning to be discussing rules governing the registration and operational mechanics of swap dealers and major swaps participants today when we have yet to define these terms. It's my understanding that we will hear from our staff on December 1st regarding these definitions. If we cannot adhere to this timeline, it's hard for me to contemplate moving forward on other proposed rules without these linchpins. The Dodd-Frank Act, passed by Congress earlier this year following a catastrophic financial meltdown in 2008. Despite whatever rhetoric you may hear on budget concerns we have at the agency, nothing can change one important fact. The Dodd-Frank Act is the law, and as such, I have sworn an oath to uphold it. That means we will continue to work diligently at the Commission to implement every aspect of the Dodd-Frank Act by the imposed congressional deadline. When we are done, I believe trading in over-the-counter markets will be more transparent and present less of systemic risk to our financial system. My hope is that the means to accomplish these goals adheres to our principle-based regulatory philosophy. My fear is that our lack of budgetary resources will lead to more prescriptive rules that include greater financial and regulatory burdens and force the CFTC to move more methodically to register new participants and approve new products. I would like to once again thank the staff at the CFTC for their hard work. They are spending long days, nights, weekends, and holidays in their office in order to create a safer financial system for every investor. They are dedicated public servants, and we owe them our gratitude.
Thank you, Commissioner Dunn. Commissioner Summers.
Thank you, Mr. Chairman. I'll just pick up on that thought from Mike and want to start by saying how much I appreciate the work of all the rulemaking teams. The process that we're working through right now and the timelines that we're working under make this very difficult for the staff, and I realize that and appreciate all your hard work on these rules. Going back to another thing that Mike talked about, the definitions, I think that is also a part of this that makes it difficult for us and the staff in promulgating these rules. In a perfect world, we would be doing the definitions first. Then we would be promulgating compliance to those rules. But that's not the way that this is working out because of the tight deadlines that are in the statute. So I know that it makes it impossible for us to try to be practical. It is what it is. Those deadlines are what we're presented with. I feel like I've used the term, we have the cart before the horse, way too many times. And unfortunately, doing things in the wrong order doesn't make this kind of progress easy for us. But I think that we have to be mindful of our resources and what the kind of budget restraints we're currently under and what we may be under if we have a CR that goes into 2011. And I think all five of us are concerned about the consequences of having a CR into 2011. But I think that we need to consider when we're promulgating these rules that analysis should be one of the important things that we look at. I feel like certain rules that we're proposing today are not an efficient use of our resources, and when I'm looking at those rules, I'm going to oppose them because I don't think that what we're doing by asking our staff to do things that they could do more efficiently is the right thing for us to do right now with our resources. In my view, when the statutory provisions are clear and Congress has not directed us to promulgate regulations, I think the relevant question for us is whether we should promulgate the regulations, not whether we can. There are specific instances when Congress included particular language in one section of the Act and then omitted that language from another section of the Act, and I think that we need to conclude that that omission was intentional. Congressional intent is not always obvious, and that is the hard part for us when we're writing these proposals. I believe it's going to be even more difficult for us when we're trying to finalize these proposals, but I do think that that's something that we need to be mindful of, where we believe congressional intent is clear. Just to end, I want to also say that staff has worked in incorporating our comments at the 11th hour, and even maybe right now, into some of these proposals, and I, again, want to say how much we appreciate it.
Thank you, Commissioner Summers. Commissioner Chilton on the line.
Mr. Chairman, just real quick, I echo everybody's thanks. We owe our staff a badge of perseverance and professionalism for their can-do spirit. All of these different policy options, this policy buffet that we have sort of in front of us, can give us these professional-grade regulatory tools. But I agree, if we're not careful, we can mess up. I was looking through a magazine yesterday, and there's one of these that has a bunch of T-shirts, and one of the T-shirts said on it, somebody has to set a bad example. And I thought, well, gosh, that shouldn't be us. We have to be really careful about how we go forward here. But these are just proposals. We can change them as we go forward. And one of the important things that I'm so pleased that we agreed to do as a group is accept these comments ahead of time. Before we actually have the proposals, we've been accepting generic comments. And I found those to be very helpful, both in the official form and in the meetings that we've had. And to the extent that staff, when they're describing these proposals, if they can mention what the comments were and how they've dealt with them or not dealt with them and why, that would be really helpful, I think, to all of us, certainly to me. So thank you to the staff, and I look forward to getting comments on all those rules that we publish. Thank you, Mr. Chairman.
Thank you, Commissioner Chilton. Commissioner Maya.
Thank you, Mr. Chairman. After Commissioner Dunn finished, I had a brief moment of panic that I picked the wrong speech up off the printer. Mine's going to sound a lot like everyone else here, especially Commissioner Dunn's. Nonetheless, I will persevere. I would like to thank the teams that have worked so hard on the rules we have here today. The staff has actively sought input from the commissioners and worked to make improvements to each of these rulemakings, and for that I'm grateful. I'd like to commend Dwayne Andreessen and Barbara Gold and their teams for their work and their respective rulemakings. I'd also like to extend my thanks to Joan Manley and Ed Riccobeni for their work on the whistleblower rule proposal. I'm particularly pleased that the proposed rule provides for an Office of Consumer Education and Outreach that can be funded by the penalties and fines collected by the Commission. I believe we can do a much better job of providing consumers with information about our markets and providing them with a forum for which they can receive timely resolution to their complaints. I'd also like to extend my thanks to Sarah Josephson and her team for crafting 4 separate rulemakings, proposing rules under Section 731 and 732, the Dodd-Frank Act, which mandates implementation of conflict of interest rules, rules establishing chief compliance officer, and specific duties for swap dealers is only 6 pages in length. However, the attendant rulemakings exceed 130 pages. The sheer length of the combined rules illustrate to me that this Commission is shifting from a traditional role as a principles-based agency to a highly prescriptive, rules-based regulator. Mr. Chairman, you deserve a lot of credit for marshaling the Commission staff resources that put together the teams to tackle the massive number of rulemakings embodied in the 2,300 pages of the Dodd-Frank Act. Let me say that I'm both amazed and proud of the capabilities of the Commission staff to develop these rules in the time frame which you have mandated. While we will differ on some of the recommended policy outcomes of these rulemakings, I am reminded that the highly prescriptive rules are not conceived out of thin air, but are the direct outcome of the Dodd-Frank legislation. In keeping with both the mandates of our statute and your time frames, I would like to make the following suggestions to improve the rulemaking process going forward and to provide some clarity to market participants as well. First, I think we should immediately produce critical definitions that define swap market participants. Specifically, swap dealer, major swap participant, and end user definitions must be released sooner rather than later. Each rulemaking that passes without some clarity regarding these definitions creates confusion and uncertainty. I hope we can address these definitions at the next Commission rulemaking on November 19th as originally planned. For example, the debate on terms of conditions for registering swap dealers, which we have today, but we have yet to provide a definition that spells out who these rules will apply. Second, I strongly recommend that we conduct a staff roundtable on the margin and capital issue prior to release of the proposed rulemaking. I would suggest that we release the swap dealer, MSP, and end user definitions prior to this hearing so the public has some understanding of who will be impacted by the capital and margin rules. Third, I think we must vote on real-time reporting rules, a real-time reporting rule proposed concurrently with the swap execution facility definition. Understanding what type of trading platforms will be permitted is essential to informing our decisions as to the real-time reporting standards and block trade limitations. Finally, I would prefer that all of the rules related to the clearing be considered during one Commission rulemaking meeting. Not one rulemaking, but at the same meeting. Addressing individual segregation, portfolio margining, and the DCO core principles will give the public a more accurate picture of the new clearing standards and the associated costs. I am very concerned about the cumulative cost of the various clearing mandates. While a primary goal of the Dodd-Frank Act was to eliminate too big to fail, I fear we are about to create a clearing mandate that makes it too costly to clear. We need to evaluate all of the clearing requirements together to understand the overall market impact. I hope we can make these necessary adjustments to our schedule in order to release these critical definition rulemakings and give market participants a better understanding of how they will be impacted by the mandatory clearing and exchange requirements, and most importantly, the costly margin and capital rules. I believe these changes will facilitate the development of better informed and more useful responses to our rulemakings going forward. Thank you.
I thank you. I'm going to, since we are in a public meeting, I can deliberate. I can respond to some of your Commissioner Amaya's. I think that one of our challenges is not only the Dodd-Frank Act and our own Commission structure and process, it's all the public consultation. And Congress was very clear that in some cases we do joint rules, but even when we don't do joint rules, we consult actively with our fellow regulators, Securities and Exchange Commission and others. So the schedule that we've laid out and the next two meetings, November 19th, December 1st, and then probably two more meetings in December, the goal has been to get the bulk of this out or maybe all of it out by that point in time. I think on the individual pieces of it that you mentioned, the definitions piece is not just our commission, it's the SEC, and it's 10 commissioners and two sets of staffs and so forth. And I'm anticipating that we can do the entity definition piece on this December 1st. I don't know about product definition. I mean, I know where it stands, but I mean, I don't know. It's two commissions, two sets of staffs, and so forth. But I'm anticipating that, too, is in December, but I just don't know if it will be December 1st. With regard to real-time reporting, we've been trying to, on all of the data rules, swap data repositories, data, and real-time reporting, to try to coordinate very actively with the SEC. And so you raised this with me, I think, 2 days ago. I think there's just a challenge of trying to move it because they may do something on real-time reporting before we do, and so we just have to all consider that on the schedule. And I think the third point that you're mentioning about the clearinghouses, I think Ananda could better address it, but I think that we had possibly that there was in two additional time frames that they were going to be done in two different meetings, but it's quite possible that Ananda and his team could help bring those together. I mean, I think those were the three pieces in there. In terms of the capital and margin and whether to do another roundtable, I think it's a question of Thanksgiving and trying to get these things done and so forth. But I'm very conscious of trying to hear from the public on all of these matters, and roundtables have helped us in 3 or 4, maybe 5 other areas as well.
Well, I appreciate it, Mr. Chairman. I do think very strongly that we need to get the definitions out, and I appreciate, I'm not privy to the conversations you and some of the staff are having with the SEC. I'm sympathetic, but determined that we should, continue to make headway. And I know some of these negotiations have forced us to slip our schedule earlier than we had hoped. I understand.
As I've said, we are human.
I completely understand, and I think the public comment issue is going to be critical. And I'm glad to hear you're open to a public meeting on this. I'm sensitive to the holidays. It's an important time. And I'm sure some staff would like to have some time at home with family, which has been rare lately. And we should get comment on it. We keeping the schedule and ignoring public comment, or facilitating a schedule that will get public comment. That's a tough decision. You have the schedule and the gavel, so this definitely falls on your shoulders. But it's a tough balance.
Yeah, but where we may differ is I think we're getting public comment throughout. I mean, there's 350 or 400 meetings. I mean, it seems as everybody seems to know our address and our phone numbers. And I think that the roundtables have helped a tremendous amount. The public comment on the proposals helps a tremendous amount. I mean, there's a whole different ways to get public comment. So I think we're getting a lot of public comment, and even proposals are just that. They're proposals. They're not final rules.
Agreed. Without a doubt, some of the more recent public meetings have been extraordinarily beneficial. Individual SEG, the CDS products, very important and good information. I think it helped catalyze the debate, which I think will lead to better rulemakings. I think there may be no more important issues out there for end users than capital and margin, and who is an end user, who is going to be a swap dealer. That affects a lot of people in this country, a lot of corporations, and it's going to mean how we prioritize the use of our capital, which is very critical going forward, especially in a tight economy. So we should definitely consider some public hearings on that.
Actually, one last thing. I don't think we've slipped on the end user. I think that one's been calendared for December since 2 to 3 months ago. And from everything George tells me, we'll be all right on that date.
Well, I think defining who an end user is pretty important to swap dealer and MSP. I think they can all be brought together. And
no, I just didn't want the press to think that we had slipped on that one.
Oh, okay.
I mean, that one's been calendared for certain.
Well, maybe here's one we can accelerate.
Mr. Chairman, if I can, just to enlighten the public, you may have read about this in the chairman's office. He's got the Big Brother king size one of these, but this is the flow chart that we have of how we're going about trying to get all of these various rules promulgated, and the blue is when we're out for comment on it and when we expect to have those. And we've been privy to this. It has slipped a little. As the chairman said, we're only human. Mr. Chairman, since I got out of graduate school in 1972, I have been involved in responding to proposed regulations, writing regulations, implementing regulations. And I must say, this has been the most open, the best run that I have ever worked with. And my hat goes off to you and to the staff in putting together the type of openness that we have had here, including identifying those 30 working groups and putting up on the internet, here's how you get a hold of those folks. For the first time that I've ever been involved with regulations, it has been the public knowing what we're hearing. Everybody has had an equal opportunity to get their thoughts down on that initial piece of paper. And even before we got to the point where we're going through the Administrative Procedure Act of promulgating the regulations. So I think the openness that we've had here has just been fantastic. The roundtable meetings, I have tried to listen in to all of those and then try to get a synopsis from the staff of what was discussed, and unfortunately those synopses are an inch or two thick when we get to them. We've been given a very, very tough job by Congress. They have imposed upon us a Herculean task of getting these regulations out. I find no fault with what we've done to date. I I do wish that we had, at least on the entities, the definitions there to work with. It's when people come in and talk to you and say, well, we have to do this or we have to do that, and we say, well, we don't know, what are you? And some of them know that they're going to be swap dealers. But there are a lot of folks out there that have, and they give us an example of what they do, and we say, gee, I have to think about that. Where do you fall under that? So for that clarity, at least getting the definition of the entities out, and it's slipped until the 1st of December. But again, it still gives folks an opportunity to look at those regs that are out for public comment and say, uh-oh, now I see where I fall. I know how to tailor what I'm going to say to it. It's a tough task that the Commission's been given, and the staff in particular. And I used to complain about us not having enough public meetings. I may be on the other side of that at this point, but I appreciate it, and I know from my interaction with the public and the industry, they appreciate it.
I thank you, Commissioner Dunn, and all commissioners for these comments. I think now, so you don't just get to sit there, Sarah and Ananda, you get to walk us through some of the rules, and I think that I'm just going to turn it over to Ananda Radhakrishnan, who heads our Division of Clearing and Intermediary Oversight, Sarah Josephson, who's from the Division of Clearing and Intermediary Oversight, but is known by so many people in the public now as the team lead for the internal business conduct standards. And there are many of those internal business conduct standards, as Commissioner Amalia said. The Dodd-Frank has already been prescriptive, and we have to bring some rules to them.
Good afternoon, and thank you to the commissioners and their staff for working with us to put these 4 notices of proposed rulemaking together. And also thank you to the team that I've been working with here, the staff of the commission to help me in putting these together. I think that I'd like to ask just at the beginning, should we take the 4 NPRMs, perhaps consider duties first, and then the conflicts of interest rule, and finally the chief compliance officer rule? Does that work? Okay. All right. So the first rule that we're proposing relates to the internal business conduct standards for swap dealers and major swap participants, and the statutory provision that we're working with is found in Section 731. It is the new CEA Part 4SJ, and it is the duties for swap dealers and major swap participants. These will be new rules in a new part of the CFR, Part 23. And what I will do is I'll just go through each rule at a high level and provide you with some background on what it is that we've done. The approach we've taken is to require written policies and procedures for a series of different aspects. And if you look at the statutory text, they require monitoring of trading to comply with and prevent violations of applicable position limits, risk management procedures for managing the day-to-day business of the swap dealer or the major swap participant, a disclosure of general information, and a provision about the ability to provide information to the Commission or to the relevant prudential authorities as applicable, a conflicts of interest provision, which will be dealt with in the second set of rules that we talk about today, and then finally an antitrust consideration section. So initially what I'll do is I'll talk about what we've done with the risk management section. The proposed rules would establish a risk management program consisting of written policies and procedures that are designed for swap dealers and major swap participants to be able to manage and monitor the risks associated with their business. The rules, again, take a policies and procedures approach that require swap dealers or major swap participants to account for a number of different risks that they face, including market, credit, liquidity risk, among others. It also would require that the swap dealers and major swap participants set risk tolerance limits for themselves. Again, these would not be set by the Commission. There's a new product policy, and I believe Commissioner Amalia, you mentioned the roundtable, and one of the things that came out of the CDS roundtable was the importance of understanding the risks that are associated with new and novel products. There would also be a provision for the use of central counterparties, that the entities have policies and procedures in place so that if there is a clearing mandate, they would clear their products pursuant to that mandate, or consider the use of central counterparties as a way of mitigating counterparty credit risk. The risk management policies and procedures would also require that the risk management personnel be separated from trading personnel. So that is what we've defined as business trading unit personnel, and that's an important separation to separate those two entities. And then finally, with regard to risk management, the entities will be required to on a quarterly basis, provide written risk exposure reports to senior management, and those reports will also come to the Commission to help us in our oversight of these new registrants. Another section of this rule relates to the business trading unit, and again, generally speaking, this is a policies and procedures approach so that those individuals who are able to commit the capital of the swap dealer, the major swap participant, know the limits to which they are subject. Again, the swap dealers and major swap participants will set those limits themselves, but it's so that they know how they're supposed to engage in their trading. This overall risk management program will be reviewed and tested on a quarterly basis by either internal independent audit personnel or external personnel. Then we have a rule on position limits, again, to comply with the statutory requirement that swap dealers and major swap participants monitor their trading in swaps to prevent violations of applicable position limits. And that requires annual training of personnel, diligent monitoring and supervision of the trading personnel, among other things. There's also an early warning system and monthly testing of that system to alert senior management, again, if position limits that would be established by the Commission or a designated contract market or a swaps execution facility, that those would not be violated. Again, we're not setting those, that's not part of this rulemaking. This is just a risk management component that once those position limits would be in place, individuals would have internal procedures to address them. There's also a rule on diligent supervision that is very much like the rule for FCMs that's in place right now, requiring that swap dealers and major swap participants establish a system to supervise their employees, agents, partners, et cetera. And then that the supervisory system designate people with authority and that they use reasonable efforts to make sure that the supervisors are qualified. There's a rule on business continuity and disaster recovery, again, that just requires the swap dealer, major swap participant to have a plan in place to be able to resume operations by the next business day following an emergency or other disruption. There's also a requirement that they notify the Commission of relevant individuals to contact in the case of an emergency, and to notify us if there is a emergency or other disruption. Again, that plan would be annually reviewed and tested, and there's requirements about geographical separation of important information and backing up important data. And then there's a rule on general information, making sure that the SDs and MSPs can provide us with the data we need in a prompt basis, and all information related to their swaps and financial integrity of those products, and generally their having internal systems in place to be able to respond to the Commission, or if they are also registered or otherwise licensed by prudential authorities, that those same, that information would also go to the prudential authority with whom they were registered. And then finally, there is a very short rule on antitrust considerations, that swap dealers and major swap participants have policies and procedures that would prevent any sort of unreasonable restraint of trade or material anti-competitive burden on trading or clearing. So that's the high-level summary of that particular set of rules.
Thank you, Sarah. And when you call it a set of rules, that's one
Yes, that is.
notice of proposed rulemaking for those, right?
Yes, it is one notice of proposed rulemaking with which we subdivided into, I think, 6 different rules.
Right.
Conference contains.
Sorry, Commissioner? No, but I was going to allow if you had questions.
A couple of questions. First of all, I'm trying to get in line because I had my questions lined up 1, 2, 3, 4, 5, 6 as we had in the notice, and we're on number 4 now. So just in case people wanted to know where we were, how is DCIO going to oversee the implementation of this? And directed primarily to Ananda, what do you see as the resources to be needed, and how prescriptive are we going to have to get if we don't have those resources to get the type of information that will be in these proposed regs?
And I'm going to apologize and interrupt. I was supposed to take a motion before we entertain questions. So if there is a motion to accept the staff recommendation and send this proposed rule to the Federal Register.
So moved.
Second.
All right, now.
Thank you, Commissioner Dodd. That depends on whether we get money. And I'm not being facetious. DCIO was asked, well, all the divisions were asked, how many people would you need to implement Dodd-Frank? And I had said, conservatively, 100 additional FTEs. Question was asked, when do you need them? And I said, the day after I asked for them, which was about a year and a half ago. Because my thinking is, if you know you're going to have a lot of responsibilities, and I'm not making fun of the government, I'm not criticizing the government, it really doesn't make sense not to get the staff as soon as possible, because it's not a matter of getting staff and saying, now go and examine the swap dealer for compliance with the Commission's regulations. You've got to train people. However, I understand government doesn't operate that way. So, I forget the number offhand how many people I've asked for, but I think we were asked for X in 2011 and Y in 2012. If we don't get these people, then I think the Commission is faced with a decision. DCIO right now is about 125 people. What do we prioritize? Do we send all of our staff to examine swap dealers and MSPs? Do we examine all of them or just the major ones? If we don't do that, who should do it? And I think in the next in the registration rulemaking, there are 3 options. One, we do it. One, the NFA does it, and then there's a hybrid model. But that's all I can say right now because I don't know how many people we would have. I would submit that it would not be a good case if the Commission staff were not involved in the examination of swaps dealers for compliance with the Commission's rules. In other words, if we did it, even if the Commission decided the NFA was going to do it, I would strongly urge that Commission staff be involved in these examinations, because otherwise we would have no idea as to how compliance is being determined. And the reason I say that is because since it's the Commission that promulgated these regulations, I think the Commission should have some experience in examining swap dealers and MSPs. Just like the Commission initially, in 74, 75, examined all FCMs, and then we got away from it because of lack of resources, and now we're trying to get back into it because after a while, you lose touch with the industry, and I don't think that's a good outcome.
We're asking for the establishment of a risk management program. Is there a gold standard out there for what that program should look like? Are you contemplating a safe harbor or guidelines for such a program?
I don't know if there is a gold standard because we have never examined swaps dealers, so we have no experience in that. I'm sure that we will probably be consulting with our colleagues in the banking sector who have had supervisory responsibilities over banking entities who are large swaps players. But the issue is, Dodd-Frank is completely new. So I suspect what they have done, and I'm sure I'll have to confirm with this, is they have examined swaps activity as part and parcel of their safety and soundness examinations, which bank regulators do. And I'm sure we'll have a lot to learn from them. But as to whether we know what the gold standard is, or is there one, I'm not sure. You could argue that there isn't one, because otherwise, why did the government have to bail out so many entities?
I won't get into that argument. Under antitrust consideration, and I'm really would like some amplification of, we're going to prohibit any action that results in unreasonable restraint of trade or impose any material anti-competitive burden on trading or clearing. What does that mean? Is that something we're going to have to go to the FTC or to justice for, or are we going to define that antitrust?
This requirement is again based on the statutory text, and it actually is found throughout the statute. Also, similar language applies to DCOs and also DCMs, I believe. Mm-hmm. And so, again, it's a unique provision in that it says that they will not adopt process or take any action that results in an unreasonable restraint of trade unless...
Could you give me an example of what that might be?
I'll give you an example. Let's say 5 swap dealers get together, form a DCO, and then don't let anybody else in. That would, cause some alarm bells to ring. We won't say necessarily that somebody's behaving anti-competitively, but it certainly would, cause one to, ask a question. What is that? Because it says, unless necessary or appropriate to achieve the purpose of the act. So the question we're going to ask is, well, why are you doing this? What's the motivation behind it? And, there's a body of antitrust law that, I'm sure we can learn from. Sarah used to be an antitrust lawyer, so that we can learn from. But Sarah's correct. I think a lot of it it'll have to depend on the facts and circumstances of each case. But, that's the one that comes to mind.
Right, and I think the only thing I would add to that is it also does have the sort of carve out in the statute, unless necessary or appropriate to achieve the purposes of the act. So we could, that is a unique part of the statutory framework. And in addition to the clearing example Ananda gave, I might also mention certain actions that could be taken with regard to valuation of swaps. So pricing, collusive behavior on certain terms and conditions of swaps and that sort of thing is what we would contemplate. But at this point, it's primarily putting into the regulation the statutory text and then requiring that the entities have policies and procedures in place to prevent that activity.
Commissioner Summers?
I don't have any questions. Thank you.
Commissioner Chilton?
No questions. Thank you.
Commissioner Amalia?
Thank you. I'd like to follow on what Commissioner Dunn had asked. He asked the gold standard question. I assume that in developing your rule that you reached out to these swap dealers for input in establishing these risk management plans. Could you give us a flavor of what we have in the rule, how that matches with the survey of the industry you took, and what might be different in your rule that you didn't see anywhere else?
Right. So, and I think I was going to add this earlier to what Ananda said in terms of gold standard. One of the or some of the source material that we consulted quite heavily is the banking supervision requirements for those entities, and they have done a tremendous amount of work in areas of risk management, identifying market risk. So the OCC's and the Federal Reserve's extensive amount of material on their supervision manuals is something that we used. We also consulted and conferred with bank supervisors and used, generally speaking, the best risk management practices that are available. In many ways, our experience with oversight of clearinghouses was brought to bear because many of the same risks in terms of getting good value, good valuations, price information is critical to understanding your market risk, your exposure to the markets, and then also to your counterparties. Your counterparty credit risk is another thing that we tried to, in a very simple way, lay out some of the key things that you need to do so that when you are engaging in these swaps transactions, that you understand your exposure from a number of perspectives. Also liquidity risk, so as many different sources as we could get our hands on in the time that we had to work on these rules. We relied on that.
Are these the pre-Dodd-Frank manuals that you referred to, or pre or post-Dodd-Frank rules?
Oh, no, this is just current bank supervision manuals. And then also talking to those entities that are likely to be considered swap dealers or major swap participants. We also got information from them. And it's very standard practice, again, to understand what your overall exposure is to markets and to your counterparties.
So you would say these risk management duties embodied in this rulemaking are fairly standard in the industry? Okay.
Yes.
Thank you.
I think I could probably just call the question. I'm in support of this. I mean, it's been a lot of years since I was at Wall Street, so I'm a little rusty. But they do seem standard to know your valuations. And what I like about this, too, is that it probably is closer. I know it's not strict core principles, but it's laying out principles for the dealers to have. It's not laying out, you must do this on Tuesday and then on Wednesday or anything. So I'm sure we'll get a lot of public comments if we put this out, but I like this because it's sort of principles-based for the dealers to do their risk management. But with that, I would ask, call the question, all in favor on the notice going to the Federal Register?
Aye.
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 Aye. Any opposed? I don't know if Commissioner Chilton's there, but...
Aye. Yeah, I said aye.
So I think it being unanimous, we'll send it along. And Sarah, you've got 3 more. So.
All right, so maybe we'll consider the conflicts of interest rules together, if that's all right with the commissioners? Okay.
There may be separate votes because they're 2 different rules, but you'll just can discuss them
Yeah.
together. Thank you.
They are very similar, if not identical, in terms of what they require. Here, what we are, the statutory text that we're working from is in 731, Section 731 of the Dodd-Frank Act. Again, the CEA section, new Section 4SJ5 on conflicts of interest for swap dealers and major swap participants. It requires that they establish appropriate informational partitions between persons researching or analyzing the price or market for any commodity or swap and persons whose involvement in pricing, or trading, or clearing activities might potentially bias the judgment or supervision of persons engaged in research. That section also requires partitions between persons acting in the role of providing clearing activities or making determinations as to accepting clearing customers. And those persons should be separated again from those individuals who are involved in pricing or trading or clearing activities. It's a little awkwardly worded there, but generally separating people providing clearing services from traders. The other section that applies to FCMs and IBs is from Section 732, the conflicts provision, which will be new. It's in Section 4D of the CEA, new Section 4DC, and that requires futures commission merchants and introducing brokers to implement informational partitions between those researching and analyzing prices and markets and those who are involved in trading or clearing. So what we've done with the rules, again, just an overview of the rules, is a separation of research from trading, and accomplishing that through placing restrictions on non-research personnel influencing the content of research reports that are prepared by research analysts, prohibiting the supervision of research analysts by people engaged in trading or clearing, putting certain restrictions around compensation that you can't consider as one factor for researchers' compensation, the researchers' contributions to the trading or clearing business. We took a general disclosure approach to material conflicts of interest. So if a researcher owns or has a financial interest in a derivative of a type that the researcher is following, that ownership interest has to be disclosed, and that the general nature of the financial interest must be disclosed. And that's both in written materials, written communications, and also in when a research analyst may be making a public appearance. There's a prohibition on retaliation against researchers who produce reports that may adversely affect the firm's business, and a number of other provisions, again, fairly limited, but all to establish that division between the research and the trading arm. And then to accomplish the important objectives of the separation between the clearing personnel and the traders, what we did, and this is about preserving access to clearing for customers in a lot of ways. That's kind of the heart of the policy concern here. So swap dealers and major swap participants are prohibited from interfering with or attempting to influence decisions related to the provision of clearing services or the acceptance of clearing customers. They also must maintain appropriate partitions between what we've defined as the business trading unit, so that's really the trading desk, those personnel, and the people who are involved in making clearing decisions with regard to accepting customers, setting fees, but basically providing the clearing services or accepting clearing customers. And then in order to make sure that there is no that the intent is fully effectuated, what we did is for the FCMs who, under Dodd-Frank, only FCMs can accept collateral from customers, so it'll be FCMs who clear on behalf of customers for all swaps and futures at this point, so that those, if there's an affiliated swap dealer or major swap participant, that they prevent the interference of the trading unit personnel from getting involved in the decisions about providing clearing services to customers. So that's the overview of the rule.
There's two rules actually, and I don't know how to do this so that I can entertain discussion on both, but I guess I'll take a motion on each and at least have them so that we can ask about both of them. So let me do a motion on the swap dealer firewall.
So moved.
Second.
All right, so that's on the table to discuss. If I can entertain a motion on the futures commission merchant firewall.
So moved.
Second.
All right, so they're both on the table. Sarah, if I could ask, and I don't mean to front run my fellow Commissioner Summers, but I find myself somewhat sympathetic to her point. We've included firewalls in the swap dealer definition between research and trading, between research and clearing, and between clearing and trading. Is that correct? You hit the mic, yes. So, and these firewalls are what the statute calls informational partitions. I am supporting it, and I am supporting the other one as well, because I also understand that these various firewalls are quite similar and tailored off of what the Securities and Exchange Commission has done at Congress's direction under Sarbanes-Oxley. Is that correct?
Yes. In fact, the FINRA Rule 2711 is the basis. We worked from that in putting together the separation between the research and the trading desk.
Right. And that the statutory language in Dodd-Frank is very similar. It may not be identical, but very similar to what's in Sarbanes-Oxley from 8 years ago.
Yes, it is.
Okay. But I think the question that comes up, and we address it in the proposed FCN rule, you have it in the preamble on pages 8, 9, and 10, is that the Dodd-Frank provisions for the firewalls in the FCM is different than the provision in the swap dealer area. It explicitly says there's got to be an information partition between research and trading, and research and clearing, but am I correct, it's silent on trading to clearing? Says, I don't want to front run you, but that's, I think, right, is that right? Yes. So why are we doing that?
Right. So the idea and the statutory authority for the conflicts of interest provision, the first part, you're absolutely right, that under 4DC1, it is a division between the research and the trading or clearing. Primarily the focus is on the trading desk. And then C2 allows the Commission to address such other issues as the Commission deems to be appropriate. And the reason to include a provision on the FCM side is to prevent regulatory arbitrage between the different affiliates. So within the same entity, you could have, going forward, a FCM entity and a swap dealer entity, both of which have trading desks, have clearing units, and you want to ensure that, and I think this is the objective, that the clearing unit personnel, those who are making decisions about providing, for instance, services to customers, that they aren't influenced by the trading desk because of a number of different concerns, but primarily it would be a competitive threat, that the trading desk would consider there to be a competitive threat to offering clearing. So this would be for cleared or uncleared swaps, that they would perhaps want to disincentivize or influence in some way the clearing personnel from accepting customers.
So is yours and staff's concern just where a futures commission merchant and a swap dealer are held in the same sort of what I'll call consolidated group?
That is the primary concern, yes, that the rule is attempting to address.
I didn't see a question, and it might mean that I need to do an amendment and get a motion, but is there a question explicitly like, I'd be interested from the public whether there's another way. Is there an alternative to address this circumstance?
We have generally solicited comment on all of the provisions, but we could include a particular question that would ask if there were alternative approaches.
I have to do it in the right procedure, but I'd like, if I get the support of my fellow commissioners, to have some more public input specifically on that.
Mr. Chairman, I'm supportive of a question. I think if it would accompany an example that you have provided that might provide a little more helpful comment. What exactly are we trying to solve here? You can draft it in the form of a question, but I think
I think that's a good idea. Is that a motion for an amendment? Just to offer an amendment. Yeah.
Make a motion.
Yeah. So we have a lot of motions on the table. I'll let others ask questions, but that's my main. I'm going to support both of these, but I would hope that with the support that we'd sort of focus a little bit more and get public input on this, which is, in essence, in paragraphs or in parts, pages 8, 9, and 10 in the preamble in the second rule. Commissioner Dunn?
Mr. Chairman, I would make a motion that we agree that any additional questions that may be brought to the Commission before 5 o'clock today or sometime would be included in here so that...
I'll second that motion. All in favor of that?
Can we debate that a little bit?
Or we'll debate on that Mike's amendment. Yes.
I mean, I just want to make sure I understand it, Commissioner Dunn. I mean, any one of us has a question, we turn it in, and it gets published in the Federal Register? Is that what you're suggesting?
On this particular rule, yes.
Huh.
Narrow it more, Mike?
I'm not so sure about that.
Mike, do you want to narrow it more? We were just trying to make sure that we could ask questions about this, but...
I mean, I'd rather see a sort of a specific question, or at least a certain band of questions. But
I guess what my motion would be is that we keep the question open for voting on it until 5 o'clock today, and then we would all vote on it up and down, whatever those questions might be. Does that make sense to the commissioners?
I have to consult I think we have to probably back off. That I have to close out my question.
Perhaps, Mr. Chairman.
He says I have to close out my question. So.
Yeah, perhaps the staff could come up with exactly what your question is while you're conducting the meeting and present it to us, which I think I'd be supportive of.
Right. And my question most specifically is whether there's alternatives to address this partition, the information partition between trading and clearing in FCM. So it's just the FCM rule, and it's the discussion on pages 8 to 10 of the preamble, whether there's alternatives to address the specific example that Sarah Josephson raised about possible regulatory concerns when an FCM is part of a consolidated financial entity that also has a swap dealer. So that's was my question. That's as tight as I could say my question.
I think just to add, to clarify, I think my concerns in this area is that the specific language that's included in 731 with regard to that is not included in 732. So I guess my concern would be that we are going beyond what I believe congressional intent was. If they wanted to include this to apply to FCMs and IBs, I think they would have.
So my question is are there alternatives, particularly in Sarah's example when an FCM is owned in a consolidated group that also has a swap dealer? Because that's what I understand. That's my tight, as best as I could tightly do the question.
Chairman, I'm fine with that question. I don't know if Commissioner Dunn wants to make that motion, but that and even that with any technical changes the staff may have, that sounds appropriate to me.
I'll amend my motion to include that.
Yeah. All right. So that question's on the table. All in favor?
Aye.
Aye. Any opposed? All right. Now we're back to questioning the Commissioner. Questions on either of these two rules?
I do, because as we're looking at the push-out provision here of this, probably before we conclude here this afternoon, the econo-bloggers, Zero Hedge or Naked Capitalists, they're going to come up with dozens of ways people can get around these provisions. And do we have a catch-all phrase in here anywhere?
I think with regard to the separation between the research arm and the trading desk, yes, the catch-all at this point is just there'll be no undue influence on the content of research reports. So that's the general catch-all for that. And then the catch-all in the clearing area is the idea that there will be no one is allowed to directly or indirectly interfere with or attempt to influence decisions of the clearing unit. So that's the best that we've been able to come up with to be able to try to get at those concerns for evading the intent of the Dodd-Frank Act.
I guess, again, my question to Ananda is, how are we going to implement this with the resources you currently have?
Again, I think it's a matter of prioritizing resources. I think, and that I hope in fact, I invite the Commission to give guidance to DCIO based on a set of resources as to where you'd like us to prioritize our work. Because in that way, you know what it is we're supposed to do, and we know what it is we're supposed to do, and we'll give you a plan as to how we're going to do it, and if you like it, we'll go and do it. So, because I think, as I've discussed with you privately, something's got to give. If we don't get additional resources, something's got to give. As much as I personally hate not doing anything, I'm a realist enough to know that with limited resources, we cannot do everything, and I think it's essential that we at least keep a finger at each of the pies that we've been given. In other words, it would be a shame if we were to concentrate all our resources on supervising swaps dealers and MSPs, and then for us to neglect the SROs and the other registrars and DCOs. So, and that's not a very satisfactory answer.
And I'm also afraid that I preempted you in my first opening statement when we started this. I asked for prioritization by the division directors of what could be or could not be done, and
Sure.
I hope we will get that by the time we get all of the rules out for comment.
Sure. And hopefully that we'll have more clarity on our what resources we have, so that we can give you that priority.
Thank you, Commissioner Dunn. Commissioner Summers? None there. Commissioner Chilton?
I don't have anything. Thank you.
Commissioner Maya? If there are no further questions, I'll first take a vote on the swap dealer firewall rule. All those in favor say aye. Aye. Any opposed? It seems that it's unanimous. Then I will take a vote on the futures commission merchant firewall rule as amended. All those in favor say aye.
Aye.
Any opposed?
Opposed.
It seems to be 4-1, and I thank you, Sarah. And if we can then move to the Chief Compliance Officer proposed business conduct rule. As I understand it, this is, again, Dodd-Frank has a whole Chief Compliance Officer, well, I'll call it regime.
Yes.
Thank you.
There was a regime. Chief compliance officers were added to several sections of the Dodd-Frank Act, Title VII. So there are chief compliance officers for swap dealers, major swap participants, and FCMs. Those are the rule that is before you today addresses those. There also are similar provisions for DCOs, CEFs, and swap data repositories. So the statutory provisions that we were working from, again, Section 731 4SK, this is the designation of Chief Compliance Officer for swap dealers and major swap participants, and then a similar provision in 732 4DD, the designation for futures commission merchants. And they are different in that the 4SK lays out specific duties and an annual report for the CCO. It's very similar, if not identical, to the provisions for DCOs, CEFs, and SDRs. On the other hand, the designation for FCMs it just sets forth, performs such duties and responsibilities as will be set forth by the Commission in regulation or rules adopted by a registered futures association. So the rule before you at this point directs that the CCO report directly to the board or senior officer of the swap dealer, major swap participant, or FCM, and the primary duty of the CCO is to establish and enforce compliance policies, and that we've defined in the rule. It includes, among other things, a conflicts of interest policy and general policies and procedures that must be in place to comply with the entity's own rules for itself, and also commission, the CEA and commission regulations. We decided to apply the same standards to and the same requirements for CCOs, for swap dealers, major swap participants, and for FCMs for a number of reasons, including, as we just discussed, in many instances, swap dealers and FCMs may be dual registrants with the Commission, may be in the same consolidated entity. We wanted to promote legal certainty for all three registrants. So having the Commission issue rules makes it possible for those entities to know that they must have a CCO and what is expected of the Chief Compliance Officer. And we've also solicited comments specifically on whether or not this was an appropriate approach to take. The rules will appear in Part 3 of the rule will appear in Part 3 of the Commission regulations. This pertains to registration of registrants, so FCMs and now SDs and MSPs. We've modified the definition of principal to include a CCO. Principal is generally CEO, CFO, and the only requirements that we've put in place for who the CCO must be is that they have an appropriate background and qualifications, and they not be disqualified under the CEA, particularly under Section 8A2. They will also be required to file a Form 8R with NFA, submit fingerprints to the NFA, from which they do a general background check. I mentioned the duties that they will have: establish compliance policies, resolving any conflicts of interest that might arise, and establishing procedures for remediating noncompliance. This statute also requires that there be an annual report, and the annual report will generally describe policies and procedures, including a code of ethics and conflicts of interest policies, an assessment of the effectiveness of the compliance policies, listing any material changes or non-compliance issues. And those annual reports will be filed along with the financial condition, the annual financial condition reporting that is in place right now for FCMs. So they file either a 1FR or a focus report, depending on their registration status, and there will be similar requirements to be promulgated in the coming weeks for swap dealers and major swap participants. They will file monthly and annual reports in a similar way to what FCMs do now. And we've also proposed a delayed effective date and solicited for this rule, depending on how difficult it will be to hire a chief compliance officer, although it's our understanding that most entities have someone who already fits this particular role. And we've solicited comment on how long it will take them to come into compliance with the rule and establish the corresponding policies and procedures. But again, for existing registrants, this is not a radically new idea.
I'll entertain a motion before we ask questions.
So moved.
Second.
I don't have questions. I'm just going to say I support putting a proposed rule out. I am interested in the public comment on it because I think, as you rightly said, I think a lot of large entities do have this concept and what Congress embodied, but I'm not entirely sure whether smaller swap dealers, and there's not everybody has this concept, and I appreciate that people have to see what the definition of swap dealer is, but they'll see that in a couple weeks. But yeah, I mean, and this rule is out for how many days? Is this a 60-day?
60 days.
So this is out for 60 days, and they'll see the definition. So I'm particularly just interested in sort of what I'll call the intermediate-sized swap dealers, what they'll be commenting. I think this dutifully does what Congress asked us to do, though, so I'll be supporting it.
It's my understanding that this is actually part of the risk management program, that they have a CCO. Is that?
The CCO will certainly be a part of that, and in certain instances they will get the risk exposure reports that I mentioned. However, the CCO should not be a substitute for a chief risk officer or to have risk management personnel in place, but they would be involved in that overall oversight, absolutely.
You indicate that the CCO would not have to register with the NFA, but that the NFA will get their fingerprint card and do the background investigation. Now, will they be able to charge for doing that service?
That's a good question. I guess I don't want to steal the thunder from the Barbara's rulemaking, but potentially they could charge the registrant, because this will be a CCO for an FCM, IB, swap dealer, and MSP. So if the NFA were not inclined to provide the services for free, they could charge the registrant. Because after all, this is going to be the chief compliance officer for a registrant. But, you should ask the NFA.
I'm sure they'll write in about that. The annual report, there are actually 7 parts into that you're asking for in the annual report. And what type of resources and how are we going to go about evaluating those annual reports and to get back in a timely manner to the CCOs that we understand what they're doing and either say they haven't hit all of those 7 areas that we've asked for or they are in compliance? That's the resource question as well, Ananda.
Right. So maybe I'll start with the what's required of them. In some ways, the annual report also serves as an internal sort of self-assessment tool. And one of the things that we've mentioned in the preamble is that it could prompt a conversation. We would like to assume that chief compliance officers are meeting regularly with the board of directors or the senior officer. But at a minimum, we've said they should meet once a year. That reflects the annual report to go over areas where conflicts of interest have arisen, non-compliance with, in some instances, their own compliance policies, but certainly non-compliance with our regulations or other applicable regulations. So that would be something that they would do on their own, and we've just set out the parameters for that. And then we would receive a copy of that, but I don't think at this point anyone's contemplating that we would pass a sort of judgment on that. It would help inform our supervision of these entities, however. And that's, I think, where it would be most useful is to sort of a direction for us to understand here where issues have come up, where they haven't, where, what that report is, that would be part of our ongoing oversight.
I guess that begs the question, if we're not reviewing the annual report, why ask them to submit it?
No, actually, we are going to review because as with every report that we ask our registrants to provide us, you're right. If we're not going to review them, why ask for it? So we, make a very conscious effort to review all reports. For example, financial reports and so on. We make a very conscious effort to review the reports. But Commissioner Dunn, you're right. This again points to yet another strain on our resources, and I just worry that if we don't get the resources that we ask for, that I hate to say this, but we'll be setting up to be failures. Because if we don't get the resources, we have all of these responsibilities. If we don't get the resources, something's got to give, and that's my concern.
I was on a panel once, this is just editorial, with David Lawton from the FSA, and he made the remark that he never asks for a piece of paper that he doesn't know what he's going to do with it. And I want to make sure that we know what we're going to do with this as we're asking for a report.
Absolutely. I think what we will do, is, as Sarah pointed out, the first go-around will be to get the reports, and then to the extent that we find that there's certain deficiencies in some report, I think what we'd like to do is sort of create a set of expectations that we can apply to everybody and say this is what we expect from a report. Because it'd be unfair if we weren't consistent.
And as just following up on Commissioner Dunn, as I understand it, I'm looking at the statute now at the very end of Section 731. Congress says directly that in accordance with the rules prescribed by the Commission, and Chief Compliance Officer shall annually prepare and sign a report. And then it gives more details about it. So this is, again, I'm supporting the rule because I look at the rule and I line it up in the statute, and it seems we're doing what Congress has asked us to do. Is that?
Right. It says that they shall prepare, and also there's the shall furnish to the Commission. So they do both of those.
Right. But I'm glad to see Dan Roth here from the NFA. And, get ready, my friend. Commissioner Summers.
Thank you, Mr. Chairman. I think my concerns with regard to these rules are similar to my concerns with regard to the rules on the FCM's IBs, that the duties prescribed in the Act for swap dealers and major swap participants are pretty clear. It doesn't require us to promulgate a rule. They seem to be pretty clear. Yet the duties for a chief compliance officer of an FCM could be delegated to the NFA, or we could prescribe those rules. I am happy that we have included a question in the proposal that asks whether or not it's appropriate for us to be imposing the same kind of duties on an FCM. But I will ask whether or not we had considered that instead of us proposing these rules for FCMs, that we would have left that to the NFA.
Right, so we did consider that, and again, I think as I mentioned earlier, our thought was that to provide the sort of legal certainty that it made sense while we were issuing the rules for the swap dealers and the major swap participants, that we would do a similar, take an identical approach in this instance for FCMs.
I know in a couple of places in the proposal it says that we are following SEC rules with regard, but are they exact to what chief compliance officers for BDs have to comply with?
Right. So in this rule, we're actually not following the SEC approach. This is based almost entirely on what the statute requires for our registrants and registered entities. But the SEC does have requirements. There's a FINRA rule for chief compliance officers for broker-dealers that is very similar. It is not identical, but it is consistent, and there are examples of where duly registered entities, so broker dealers and FCMs, have consistent but not identical requirements. Record keeping is one of them.
Commissioner Chilton.
Question. Thank you, Mr. Chairman.
Commissioner Malia.
Sarah, I'd like to ask you a question regarding kind of the philosophy of this rule. Like it or not, it's in there. We've got, I don't know how many times CCO is mentioned in the statute, but it's clearly in there. And I guess my question in the principles-based versus rules-based, we've seen some different drafts of this rulemaking that have been much more prescriptive. And I guess we can look at this in two ways. One, providing the kind of the guidance and principles approach to a CCO, which would, kind of serve as our front line of defense in terms of establishing good procedures and conduct within a company. That obviously resolves our ability to go and investigate in a much more prescriptive way. The other version being a very prescriptive, setting specific standards, et cetera, and kind of playing gotcha with a CCO. And then, so how do you view this? Are we going to use them as a tool, or is this something that we're going to kind of go by chapter and verse to really enforce something here?
Right. So again, I think that the approach we took with elaborate was to stick as closely to the statutory text as we could. So that's where the establishing compliance procedures, having the annual report that requires them to provide a description of their compliance with policies and procedures that they have, where we tried to do that. And then because we took from the requirement that they report directly to the board a few enhancements on what the nature of that relationship, so that the board sets compensation and that they'll meet at least once per year. We also added the sort of minimum qualifications for this position, and this is in keeping with the background and skills appropriate, and also that they can't be statutorily disqualified under the CEA. So that is the idea. And again, I think as Commissioner Dunn's question got at, is what role this person plays is really very much up to the entity. Aside from the annual report and the overall compliance, but they can use them. And we do ask some questions about whether it would be appropriate to have a general counsel serve as the CCO. Some of those, but there's really a lot of flexibility that we tried to allow for the entity to incorporate the CCO into it. And for instance, we did this with the risk management that we discussed, that they'll at least see it. Now they could be more involved, but sticking to the statute and maintaining a degree of flexibility. And one of the examples of that I would point to is the reporting to either the board or the senior officer.
I'm sorry, Commissioner Dunn.
Mr. Chairman, if you would indulge me here while I kind of follow up on something that Commissioner Summers was going on. And Later on, we're going to take up the actual registration, and in that, I think there are three options that we have in there as far as the role of the NFA. Either we do it all, or we delegate it with them, oversee them, or we let them do everything. Commissioner Summers, if you'll indulge me in this little colloquy, was that kind of what you were getting at?
Because the statute under the designation of a chief compliance officer for an FCM contemplates that the rules either be adopted by us or by a futures association. My question was whether or not we had considered us not doing these rules for FCMs. It's very clear what the duties will be for a chief compliance officer of a swap dealer or a major swap participant. But I guess I would suggest that congressional intent was not that clear with regard to what the duties would be for a CCO of an FCM.
I would ask, is the way the rule is written at this time, does this allow the public to comment on that particular question?
Yes, it specifically requests comment on that decision that the Commission may take.
If I may just add one more thing. I do take Commissioner Summers' point that the statute does provide an alternative, although I find it's always useful for the Commission to issue a regulation because it provides guidance to the NFA or the RFA. Or what the NFA could do is perhaps augment the Commission's rules. So, for example, we found that out through the whole Forex saga, where we did not have rulemaking authority, but basically relying on the NFA to regulate this industry. And, and the NFA, God bless them, did a really good job. But now that we have the authority, and I think it's important that, we set the standard and for the NFA to not pile on, but join up. So.
I'm smiling because, as the Southernism, when you say bless her heart, you're getting ready to give them a zinger.
I think the motion being made and duly seconded and fully discussed, and even with that, all those in favor say aye.
Aye.
Any opposed?
Aye.
Where are you?
I'm opposing.
Opposing. All right. It's 4-1. Sarah, are you now out of the hot seat? All right. Who wants to go next?
It's Barbara.
Barbara Gold. We're going to consider next the registration requirement, or the rule for the process for registration. Barbara Gold from the Division of Clearing and Intermediary Oversight is going to be joined by Chris Cummings and William Penner. And I'm gathering Ananda will stay at the seat as well. Thank you. The floor is yours, probably Barbara, right? Who's taking the lead?
Okay, thank you. Good afternoon. Thank you for your assistance in developing these regulations, and I'd also like to thank the members of my team, and in particular those members of my team with whom I work with in DCIO. William Penner, Taloria Glaze, Elizabeth Miller, who's the newest member of my team, and Chris Cummings, who's the most senior member and the person I think of as my right and left-hand man. I'd also like to acknowledge the technical assistance of Mike Crowley of NFA, Associate General Counsel there, in developing these regulations. The substance of the rules that my team has been responsible for concern the following: the registration process for swaps dealers and major swaps participants, who I'll call swaps entities, the prohibition against a swaps entity permitting a statutorily disqualified person to associate with it, and requirements applicable to affiliates of an insured depository institution created to trade swaps for the purpose of permitting the institution to retain its access to certain federal assistance. These we'll refer to as push-out affiliates. The sections of the Dodd-Frank Act that these rules relate to are as follows. Registration process for swaps entities, Section 731, to be codified in CEA Section 4SA. The prohibition against statutorily disqualified associated persons in Section 731 of Dodd-Frank, to be codified in CEA Section 4SB6, and push-out affiliates are discussed in Section 716 of Dodd-Frank, and there's no specific CEA codification. I would note here that the registration process package wouldn't propose any particular rules for push-out affiliates. It would make clear, however, that if a push-out affiliate came within the swap dealer or major swap participant definition, it would be subject to registration as such. I would pause here to say that we've specifically coordinated with the FDIC in this area, received comments from them. They are verbatim in the preamble to the Federal Register release. The FDIC did not have any specific comments on the rules themselves. Okay, as Sarah has mentioned, Part 3 of the CFTC's regulations provide for the registration process for existing registrants, such as FCMs, IBs, retail foreign exchange dealers, and so on. The proposed registration process for swaps entities would closely follow the Commission's current registration process scheme. And in fact, the work we've developed follows closely the regulatory package the Commission recently approved for the registration of retail foreign exchange dealers. So looking at the existing Part 3 rules, some regulations wouldn't need to be changed because they generally refer to registrants or applicants for registration. Other regulations wouldn't need to be changed because they specifically apply to certain categories of registrant, such as to floor broker or to floor trader. For some regulations, all that would be needed would be to add the term swap dealer or major swap participant to the title of a regulation or to its introductory text. However, there are some regulations that would require specific additions or amendments to reflect the nature of swaps entities' businesses and certain timing issues, which I'll discuss later. The registration process for swaps entities would commence with the filing of the Form 7R with NFA. This is the same form that all other applicants for registration, IBs, FCMs, RFEDs, and so on, file. Additionally, swaps dealers' principals, those being officers, directors, 10% or more shareholders, and pursuant to Sarah's proposal, CCOs, would be required to file a Form 8R with NFA, and they would also be required to provide fingerprint cards. These, the Forms 7R and 8R, are the basic registration process forms that provide background information, including information on disciplinary history. The question, of course, is what happens next? To become and remain registered, swaps entities would be required to meet and maintain requirements such as capital, internal business conduct, which you all just voted on under certain of Sarah's rules, and external business conduct standards. I'll be referring to these requirements as the Section 4S requirements because they're now all contained in Section 4S of the CEA. The rules concerning these requirements are being developed by other teams, as Sarah has presented some of those, but because a swaps entity applicant would be required to meet the applicable Section 4S requirements to become registered, it's appropriate to talk about the 4S requirements in connection with my presentation. Specifically, that talk concerns just who would be responsible, who should be responsible for determining that a swaps entity has initially met and continues to meet its Section 4S and other compliance requirements. In this regard, and as both Ananda and Commissioner Dunn have stated, the Federal Register release proposing the process for registering swaps entities would ask for comment on the following 3 options. 1, whether the Commission should have sole responsibility. 2, whether NFA should have sole responsibility. Or 3, whether there should be some combination of responsibility, and if so, what that should be. Further in this regard, and to provide for maximum flexibility in implementing the registration process, the scheme would propose that swaps entities become and remain a member of a registered futures association. Currently, there is one association that has applied for and received registration as such, and that is the National Futures Association. The registration rulemaking process would also address certain timing issues. One of those issues, and we've heard comment about that earlier today, one of those issues concerns the requirement to register to comply with applicable requirements versus knowing whether you are or are not a swap dealer or a major swap participant. These issues come up because the Commission must issue swap dealer and major swap participant definitional rules by no later than July 15, 2011, to be effective no earlier than 60 days thereafter. However, the Commission must have in effect rules that provide for the registration of swaps entities by no later than July 21, 2011. So accordingly, while rules providing for registration process would be effective July 21, 2011, swaps entities wouldn't be required to be registered until the effective date of the definitional rulemakings, which would be no earlier than 60 days following July 15, 2011. Basically, they would have 2 months after July 21. All right. Nonetheless, to permit persons to commence the registration process in sufficient time, the registration process rules would be issued on April 15, 2011, and in accordance with the provisions of Dodd-Frank, persons would be able to, but they would not be required to be registered at that time. They would only be required to be registered when the definitional rulemakings become effective. The other timing issue arises from the fact that the regulations implementing the Section 4S requirements similarly may not be known or may not be effective by the date swaps entities have to be registered. To address this concern, the regulatory process would provide for provisional registration. As a Section 4S requirement became known and effective, compliance with it would be required. Failure to comply would result in withdrawal of a registration application, although under the proposal, the applicant would be permitted a period of time, 30 days or longer upon request and permission. An applicant would be permitted a period of time within which to cure a deficiency that has been noted to it. Once all of the Section 4S requirements become known and effective, no more provisional registrations would be issued. Finally, and as I stated above, this rule writing concerns the prohibition against swaps entities permitting persons who are subject to a statutory disqualification from associating with them. The proposed regulation would repeat this prohibition. However, the Federal Register preamble specifically would ask for comment on how swaps entities could conduct background checks or otherwise fulfill this requirement. And among the options noted are submission of fingerprint cards to NFA for the type of fitness review that NFA conducts for existing registrants. Thank you, and I, along with William and Chris, are available for questions.
Entertain a motion on the staff recommendation.
So moved.
Second.
I had a question on the provisional, quote, provisional registration, and I was looking in the book, but I just couldn't find it. Where is that a mandate of Congress, or is that something that the staff is?
This is something we developed. There currently is a provision for a temporary license for certain types of registrants under certain circumstances, and this is something that we developed to work with the different timelines, the different deadlines required by Dodd-Frank.
I thought, and I see Dan there too, I thought there was something in statute that Congress William?
There is something in, There is something in section, I believe it's in section 731 that says registration can commence before the July 21 deadline. It doesn't refer to it as provisional registration. We did that because of the difficulty of coordinating the registration date with the definitions and subsequent 4S requirement dates.
So could you point me to where Congress tells us to, or that we may, or tells us to, or something?
Dan tells me it's 712F.
712F.
It is in a footnote in the Federal Register release. I will find that.
Oh, all right, great. But I was looking to the law itself.
Yeah. No, it's
Dan, do you
weird.
have a page?
276.
What's that?
276. Brown.
The Brown book, 712, you said D?
F.
F.
The very end of 712.
Oh, yes, it's in footnote 21 of the Federal Register release. It says, this advance application procedure is authorized by Section 12F of Dodd-Frank, which states in relevant part, notwithstanding the effective date of any provision of this Act, the Commodity Futures Trading Commission may, in order to prepare for the effective dates of the provisions of this Act, register persons under the provision of this Act, provided, however, that no such action shall become effective prior to the effective date applicable to such action under the provisions of this Act.
So, as I understand it, Congress allowed for, and staff is recommending, that even before all the rules are effective, that swap dealers could come in early, basically.
Yes,
and
they can commence the process, yes.
Commence the process, either through option 1, 2, or 3, whatever option. It might be through the NFA or through us, but they could start.
They could start,
this
but there
process.
is no requirement.
But there's a clear congressional authorization. I suspect there may be some differences amongst the commissioners. One of the reasons I support this is because I think, particularly in a resource-constrained environment, we might have, we don't know for sure, but it may be somewhere in the order of 200 swap dealers. This will allow some of them to come in early, right? This is just optional. So if we were successful, and I say if, but if we were successful finishing up the registration procedure by next April, then they could come in, they could get their fingerprints done, they could get some of their preliminary forms in. That's how you've laid it out here.
Yes.
And then if they didn't want to come in, they're still allowed to do their business, right? There's nothing
That's
constraining
correct.
them.
The deadline would be the effective date of the definitional rulemakings.
So I strongly encourage the public, whether it's on the rules we just voted out for SARA, or other rules on swap dealers as we go in the next couple of months, all the way to the capital and margin rules, that, and they may be the last, if we do another roundtable. But the effective dates, this registration rule, I want to just clarify, this registration rule doesn't limit what we'll do in other rules on effective dates.
That's correct. Yeah.
So if we decide as a commission to give people 6 months on something, or a year, or I don't foresee it, but 20 years, this doesn't limit us.
No.
So that we get to consider the public comments on each, whether it's capital margin, business conduct, record-keeping reporting, in each of those places.
Yes.
What this rulemaking would do, what this rulemaking would do would be to fulfill the statutory mandate that the Commission have in place on July 21, 2011, rules that provide for the registration of swap dealers and major swap participants.
I see. So it's another place where the statute has, we're sort of threading a needle a little bit. I see,
Yeah.
Dan.
That's right. And what Barbara's attempted to do here is satisfy that deadline and key ultimate registration to the final effective date of the last of the 4S requirements. So whatever the effective date of that last rule is when registration becomes fully effective, whenever that is.
But as I understand, people could come in earlier, get the fingerprinting, getting things, a lot of the questions they might have. So in effect, over next spring and summer, we'll have people hopefully starting the process, but they really won't be effective until the fall, or even possibly into 2012.
If I may, they can start registering once we put the rule out, and they're not required to be registered until the definitional rulemaking becomes effective. They will still be provisionally registered until such time as all of the 4S requirements become effective. Then they become fully registered if they come into compliance with all of those 4S requirements as they come into effectiveness.
I see. It would be my hope that the definitional proposed rules are out in the next few weeks. I'll say that again.
This also gives the
But they're finalized by next July, for sure.
This also gives the opportunity for entities who know they're going to be swap dealers. And there are some people in this world who know, or some, they know they're going to be swap dealers, to start the registration.
Ananda, I agree with you.
Yeah.
I think two-thirds or three-quarters, maybe 85% know who they are. They've read the statute. The statute has a pretty prescriptive, detailed definition. But it's important. There's the people on the margin. I don't have other. I'm going to support the rule, but proposed rule. Commissioner Dunn.
Mr. Chairman, maybe the question is not do they know who they are, do we know who they are? Barbara, let me congratulate you for explaining why the cart's before the horse. I really appreciate it. You did an excellent job there.
My right and left-hand man did a lot of that, too, so.
And Mr. Chairman, just to echo what you just said, it really is imperative that we at least begin that process on December 1st so that people understand where they are. Could you give me an idea of how the determination if someone is in compliance with 4S, how is that going to take place and what type of resources are we going to be needing there?
I can't. I'll leave that for Ananda.
Again, the proposed rulemaking has three options. One option is to let the NFA, or let us do it. The other one is to let the NFA do it. And the middle one is a mixture, and we ask specifically which one should we have and which one should they have. The NFA, yeah.
I understand the delegation that we have in there. That's the question. I'm talking about the actual process you go through in determining whether they're in compliance.
I would say that would be left up to each of the team leads who are developing those rules. For example, the capital rules. I don't know what Thelma will be proposing. Sarah may have information in her rules. If not today, then I'm sure going forward. And so on. I think it depends on the individual 4S requirement rule.
So we won't know how much of a job this is until we see the totality of all the proposed rules.
Because I think what we could do is, once we know the full extent of all of the rules, start creating a program or a template for, or sort of a checklist for compliance, so that, if you get an application, let's say we have to do it, we can go through the checklist and say yes or no, yes or no. It's not as easy as that because it'll require a lot of people, but that's what I'm thinking about.
Commissioner Summers.
Thank you, Mr. Chairman. I just want to clarify my concerns with regard to the registration and make it clear that my concerns are not with the substance of the registration for swap dealers or major swap participants, but just with the early registration. I'm concerned about the resources of the Commission and for entities that can not only not demonstrate compliance with any of the 4S regs because they don't know what they are, but also can't confirm that they meet the definition because the definitions may not be done. I just question whether or not it's a good use of our resources to be going through provisional registrations by this April 15th deadline before everything else is in place. So, thank you.
Can I ask this of Commissioner Summers? So there's two bits that are early, and I see that actually it might be less separates us than I had thought. There's the period of time from when the definitions are finished, which I'm completely committed to finish by July 15th of next year. There's a period of time between that July 15th and the effective date of all the 4S rules, because hopefully we'll give people, some time to get ready. And then I just heard you say you're concerned about the provisional. If we finish Barbara's rule by April, it's the period between her rule and the definitions. Is it just that latter piece, that difference between until the definitions are finished?
And additionally, the compliance, all the 4S requirements as well. So being able to say, when you register, that not only am I confirming being registered as a swap dealer, that I comply with the definition of being a swap dealer, but that I also am confirming that I am in compliance with all of the 4S regs. I think that doing that all at once, staff being able to check that box instead of sort of a piecemeal process here would be a more efficient use of our resources.
Right. Okay. I mean, as you know, support this because I think it might actually facilitate market participants to kind of early file, but I respect what you're saying as you're worried it may be a drain on resources, whereas I think it might smooth it out because at least they can take care of some of this maybe as early as May and June, but I see what you're saying.
It also calls to question whether or not there may be compliance regulations that people see during this process that they either can't comply with or don't want to comply with and decide that they don't want to be registered in that capacity because of the requirements. So registering early to me just seems odd.
Am I right? We're just giving a choice. It's not a requirement, right?
Right.
That's right. It is a choice.
Yeah, all right. Commissioner Chilton?
No, other than, that's why we do the proposal. Maybe people will come in and tell us that's not a good option. And so I'm open to changing it as we go forward, but it's just the initial step. I don't have any questions. Thank you.
Thank you, Commissioner Chilton. Commissioner O'Malley?
Thank you. I am pleased that the rule contains an option that would allow the NFA to collect and perform the required oversight of the swap dealer registration program. This really will enable the Commission to leverage the resources of the NFA and to minimize the need to devote resources and staff time to reviewing applications and the compliance of the swap dealer rules. It makes little to no sense to hire high-cost federal employees to do this oversight work that a private sector can do at lower cost and financed through fees. This option should expedite the review process and insulate it from the inconsistencies of the federal appropriations process. While the it's much discussed pre-registration proposal is provided, I do agree with Commissioner Summers that few will avail themselves to this, but that's why we asked the question. Thank you.
Just one thought. Despite the propaganda in the press, we are very low-cost employees. We are the federal employees. If you look at the comparison to the private sector, we're very low-cost, effective ones. Thank you.
Maybe we should have a staff roundtable on that.
Well, I'd say you've been enormously effective. I mean, it's just like remarkable. With that, I think I'll call the question. All those in favor say aye.
Aye.
Any opposed?
Opposed.
So we have 4-1. Thank you very much, Chris, Barbara, William, for your excellent work. Get ready for 60 days of comments. And Dan, don't go away. You're going to... Dan Roth from the NFA, who I'm picking on to the public a little bit as we change chairs here. So are we going to whistleblowers next, and Foreign Board of Trade will be last? Or whistleblowers, there we have it. The next role is some of our colleagues are coming into the chairs is to comply with the congressional mandate that we set up a whistleblower program and the procedures around that whistleblower program. And I think Ed Riccobini from the Division of Enforcement will be presenting along with, oh, no, we have 4 people. Okay, I have to make sure that I have everybody.
Mr. Chairman, this is Leslie Randolph with OGC, and Anthony Hayes, also from OGC, are 2 of the members on our rulemaking team.
And Vince, our acting head of enforcement.
Absolutely.
Good afternoon.
Good afternoon, Mr. Chairman and Commissioners. My name is Edward Riccobene. I'm with the Commission's Division of Enforcement. I'm here with my rulemaking team, concerning staff recommendation regarding a notice of proposed rulemaking to implement the new whistleblower incentives and protective provisions of Section 748 of the Dodd-Frank Act. Before I present the proposed notice, I'd like to introduce the other members of our team. I've introduced Leslie and Anthony. Pamela Gibbs is also a participant on our rulemaking team as the Commission's EEO Program Director. Mark Carney, the Commission's Chief Financial Officer, and from the Office of the Chief Economist, Christian Sorensen and Michael Pennick. I'd also like to thank Tim Carpont for the Chairman's Office, Vince McGonigal, the Acting Director of Enforcement, and Joan Manley, my Deputy Director of Enforcement, for their hands-on assistance and guidance in this matter. I'd also like to thank Steve Cohn from the SEC Chairman's Office and the SEC staff implementing the comparable whistleblower provisions under Section 922 of the Dodd-Frank Act for their invaluable and generous cooperation and assistance in this matter. In Section 748 of the Dodd-Frank Act, the Congress amended the CEA by adding Sections 23, which directs the Commission to issue final rules implementing whistleblower incentives and protections within 270 days of the date of enactment. Specifically, Section 748 requires the Commission to pay awards to whistleblowers who are individuals that provide original information to the Commission, which leads to successful enforcement of the Commission action that results in monetary sanctions exceeding $1 million. The amount of the award is determined by the Commission. Will be between 10 and 30% of sanctions collected in either the Commission action or related action that is based upon the same information provided by a whistleblower. The Commission's award determination is dependent upon certain criteria. The Commission may exercise discretion in granting an award based upon the significance of the information provided, the degree of assistance provided to the Commission, in support of the Commission's action or the related action, the Commission's programmatic interests, and other criteria. An award will be denied to certain government employees and others who are statutorily ineligible. And a whistleblower may appeal to the appropriate U.S. Circuit Court of Appeal a Commission award determination, including the Commission's determination as to whom to pay an award, the amount of an award, or the denial of an award. The Commission will pay whistleblower awards from the Commodity Futures Trading Commission Customer Protection Fund, which was established under Section 748. The Commission will also use the Customer Protection Fund to finance customer education initiatives. The Commission will deposit into the Customer Protection Fund civil monetary penalties, disgorgement, and fines collected by the Commission and covered administrative and judicial actions up to a $100 million balance. Whistleblowers may receive an award based upon violations that occurred prior to the date of enactment of the Dodd-Frank Act, and whistleblowers who submit information after the date of enactment but prior to the effective date of these rules will also be eligible for an award provided they comply with the Commission's procedures within 120 days of the effective date. The Commission has already begun to receive tips from individuals identifying themselves as Dodd-Frank whistleblowers. Section 748 provides whistleblowers who submit information after the effective date with certain protections against retaliation, including a federal cause of action against their employers. Under this anti-retaliation cause of action, prevailing whistleblowers are entitled to certain relief, including reinstatement, back pay, and compensation for other expenses, including reasonable attorney's fees. In the notice, staff is recommending the Commission seek comment with respect to all aspects of the proposed rule during a 60-day comment period. The Commission will, in a future rulemaking, address related internal, procedural, and organizational issues, including establishment of and delegation authority to an office or offices to administer the Commission's whistleblower and customer education programs. Thank you, and we'll be happy to answer any questions you might have.
Thank you. First, I'll entertain a motion on the staff recommendation.
So moved.
Second.
Ed, if I could ask, and I'm supporting the rule, and I think, as I understand it, it's consistent with the 8 very detailed pages of legislative text on these provisions. But I did have one question. Let's say this were the final rule, if this went in. Has the Commission delegated its authority to actually set the numbers. Let's say somebody is duly, should get their 10 or 30% of something. Have we delegated to somebody, or do you need to still come back with a recommendation on that? You want to hit the...
Under the proposed rulemaking, that authority remains with the Commission, and it would require a follow-on rulemaking to delegate it to an office or division.
I don't know where my fellow commissioners will come out, and it certainly doesn't have to happen before December 15th. But I, for one, would like some recommendation for staff. Maybe it's won't be supported by others, but I think that if we as a full commission have to sign off on every single one of them, that may be appropriate over a certain dollar amount. But there may be ways to delegate part of this for smaller whistleblower claims or smaller awards. And if not initially, certainly over time we'll gain enough experience that we could hopefully delegate some of that to staff. But I didn't have other questions. Commissioner Dunn.
Well, first, a general statement. I hope when we get this program growing that there is communications with whoever is a whistleblower. And a lot of time, what we're saying in here, that there may be more than one person as a whistleblower. But I think we owe it to someone who blows a whistle on something that we communicate with them our follow-up on what they have blown the whistle on. And frankly, I just think we haven't done a good job in the past in that, and we need to be able to follow up on it. Those that are eligible for the whistleblower provisions in there is a great deal that are folks that are excluded by statute. And Ed, could you kind of amplify or enumerate that for me?
Well, I think there are a list of a number of employees of government agencies, specifically a number of the financial regulators would not be eligible for an award. Employees or officers of a registered entity or a self-regulatory organization would also not be eligible, as would be the employees of law enforcement agency.
But employees of a registered entity are often the ones that are going to see what is happening, and where they are excluded by statute. Am I correct in that assertion?
You are correct.
Commissioner, are we talking about some of the exclusions are provisional exclusions, so in connection with the registered entities, internal business function where we want to encourage internal reporting and compliance functions, that the proposed rules have a protocol that's in place that if there is an obligation that currently exists upon an employee, either by virtue of their supervision status or their compliance obligation, that they will be provisionally excluded from the application of the whistleblower rules, because we want the internal compliance program to work first, but that after a certain period of time, and the proposed rules have language about a reasonable time, maybe 60 days or 90 days, whatever that time frame is, that if then the company, and I think that this is a very important provision, frankly, from an enforcement perspective, talking about self-reporting, that if the entity then doesn't self-report, we have the ability, or the whistleblower then has the ability to become a whistleblower and actually come forward with information, so long as that information otherwise satisfies the requirements under the whistleblower statute. So I do think that there is a natural, I would say, tension between having the companies or the corporations go through their compliance function and take on their obligations affirmatively, with the opportunity for a whistleblower who identifies conduct to ensure that that conduct is addressed appropriately by the regulator.
The follow-up, Vince makes a very important distinction that what is statutorily prohibited is be an employee of a registered entity, which is a defined term under the CEA, and not of a registrant. So But there are certain provisions allowing the compliance, as Vince has pointed out, compliance staff in certain situations to make a report to the Commission.
So when someone registers with the NFA, that will be made known to them?
Well, I think that, again, the term registered entity is, I think, most commonly used with respect to designated contract market, and commissioned registrant would be a different category.
So just to clarify on Commissioner Dunn's question, an employee of a designated contract market statutorily cannot be a whistleblower. Is that what you're saying?
Correct.
But an employee of a swap dealer, though that's a registered entity, it's a registrant, thank you, Joan, is a registrant, they could be, as long as they comply with everything else, a whistleblower.
Correct. And I think that focusing on some of the preliminary comments that the SEC is receiving regarding their comparable provision under Dodd-Frank, there is a lot of interest and concern for how it is going to be handled to encourage people to still use a firm's compliance program and reports to that. And on the other hand, there's Whistleblowers Council that's concerned that if it's required that they go through the compliance program, that whistleblowers will be discouraged.
Right. And I see, Dan, were you? No, all right. So
there was one point of clarification that Dan had pointed out to me. With respect to the delegation, the Chairman, you had asked the question concerning whether the Commission currently has the authority or whether the rule currently provides for a delegation. And there is a delegation that's contained in the proposed rule with respect to delegating the authority to the Executive Director and then leaving open then the potential for further delegation within the Commission.
And again,
okay,
just to
so
follow,
that's, to me, good news.
although, just as a clarification, the delegation to the Executive Director with regard to payment of whistleblower awards and the funding of the Customer Protection Fund, it doesn't include a delegation of the Commission's authority to make an award determination.
All right, so I would just hope that sometime, and it may be after we gain experience, that the smaller dollar ones, that there's some way that a 5-person commission, I mean, we've got a lot that goes on, that we may find a way, and I would seek staff suggestions on the smaller, at least the smaller sized ones, whether to delegate determinations. But again, not by December 15th, it might not even be before July 15th the next year, but that's where I would directionally want to be. I had a question that I was asked last night, actually, by a member of the press. How similar is this to the SEC whistleblower rule that they adopted a couple weeks ago?
As I noted, Steve Cohen and the rest of the staff of the SEC have been extremely cooperative. We have tried to keep our rules as similar as possible to the extent that the provisions are relatively comparable under 748 and 922 of the Dodd-Frank Act. Organizationally, the rules are perhaps a bit different. There are some differences based upon statutory differences between our two provisions. For example, the SEC's language requires them to establish a whistleblower office. Ours does not, so that's why we have left that issue of organization to a future rulemaking. I think, from my read of it, I think a significant difference that goes to statutory interpretation rather than differences in the statutory provisions is in how the Commission's proposed rulemaking would handle the determination of an award. Under the Commission's proposed rule, the whistleblower award could be based either upon amounts collected in the Commission action or a related action. The SEC's proposal would have the whistleblower award based upon a certain percentage of amounts in both the SEC action and the related action.
Thank you. Commissioner Summers?
I don't have any questions. Thank you.
Commissioner Chilton?
No questions. Thank you.
Commissioner Malley?
Thank you. I do believe we can do a better job of protecting consumers from fraud and deception, and by providing the resources necessary to fund consumer education and outreach and this whistleblower, I think we're making a positive step forward. This does allow for the venue and the funding to be paid through penalties for whistleblower awards and a freestanding office focused on public protection. This agency does many things well. However, educating consumers and providing an effective venue for complaint and resolution and adjudication are two activities we do not do well. I hope this rulemaking will encourage us to take a more comprehensive look at how we treat market participants and resolve their complaints. Now, I have a couple of questions. You had mentioned the slight difference in the SEC and CFTC award. Is it possible, if somebody brings a Ponzi complaint to both the CFTC and the SEC, and we take that to court, is it possible they can collect under our authority and their authority, under both?
Yes, they could be under our rules. They would be a whistleblower under our program. The Commission can make a determination to grant them an award based upon sanctions collected in our action or the SEC action. Under the SEC's proposal, the whistleblower would only be entitled in that situation to an award based upon sanctions collected in the SEC action.
The definition of whistleblower is limited to persons who provide information with regard to violations of the CEA. However, certain violations, notably under the new Anti-Disruptive Trading Practices Authority, may only appear in the regulations. Does this mean that a whistleblower cannot collect as a result of those violations?
That is an interesting issue, and the staff, under guidance from the Office of General Counsel, decided that for purposes of these proposed rules to strictly interpret what is provided under the statute, and the statute only refers to violations of the CEA.
So we're going to, and I thank Commissioner O'Malley to draw attention to that. So it's not just disruptive trading practices. We've just published a proposed rule, which I assume at some point we'll finalize, on anti-manipulation. What's the view of the Office of General Counsel as to whether this whistleblower 3 years from now brings something under the anti-manipulation rules, the disruptive trading practices rules, or any other rule, because we have a lot of rules that we're doing. Does that mean you're not a whistle? You can't get an award?
Those rules are enacted under the authority of the Commodity Exchange Act, so a violation of those rules would be a violation of the Commodity Exchange Act as well. Not all of the Commission's rules are grounded in the Commodity Exchange Act. So if it's a rule basically that's grounded in the Commodity Exchange Act to implement the CEA, and therefore you're violating the rule, you're violating a requirement of the CEA, you're eligible. But not all the Commission's rules are CEA authority rules, if that's clear.
Thank you, Commissioner O'Malley, for letting me interlope. I liked your answer a little bit better than Ed's. Thank you. If there are no further questions, I'll call here, Commissioner Dunn.
Do we have any other opportunities in here? I mean, I'd like to give them a bonus when somebody is actually convicted for a civil or other criminal activity in there. We're precluded by law to just follow that formula that.
Correct. There is a disqualification from eligibility if you are convicted of a criminal violation related to the information that you're providing.
No, I would like to have a bonus given to the whistleblower if somebody they blow the whistle on is convicted of a criminal offense.
Again, I think that the Commission has a wide range of criteria they could develop, and it would be assumed that these elements would be considered in any internal procedures that would be developed in the determination process. So there is a possibility, I would assume.
No further questions. Call the motion. All in favor say aye.
Aye.
Any opposed? Appearing to be unanimous, 5-0. We'll send this along to the Federal Register as well. I thank the team, Leslie, Ed, Vince. We have one more. Foreign Board of Trade. I'm told as I call this up, that we'll be considering the staff recommendation on registration of foreign boards of trade as amended by amendment number 1, if I've said that correctly. But the only amendment number 1 to my fellow commissioners is the one that we chatted about as we've been passing around. David Van Wagner, who's the, if I have you wrong, General Counsel of the Division of Market Oversight? Chief Counsel?
Chief Counsel.
Chief Counsel of the Division of Market Oversight. I'm sorry, because Dan probably cherishes the other term. Most days. And Dwayne Andreessen, who is in the Division of Market Oversight, and in one team lead meeting told me he was just an island. He was just doing foreign boards of trade. Well, for an island, you certainly have gotten a lot of interest from your commissioners.
That we have.
We hand it over to Dwayne and David.
Mr. Chairman, Commissioners, the Dodd-Frank Act provides that the Commission may adopt rules and regulations requiring registration with the Commission for a foreign board of trade that provides its members or other participants located in the United States with direct access to its electronic trading and order matching system. The Commission may adopt rules and regulations prescribing procedures and requirements applicable to registration. For purposes of any such registration, the Dodd-Frank Act defines direct access to mean an explicit grant of authority by a foreign board of trade to an identified member or other participant located in the United States to enter trades directly into the trade matching system of the foreign board of trade. The notice of proposed rulemaking before you would establish such a registration requirement in new Part 48 of the Commission's regulations. It creates a process that starts with the requirement that a foreign board of trade must be registered in order to provide direct access. It also includes criteria of eligibility to determine if a foreign board of trade is eligible to be registered. The proposed rule would create transparent standards that must be met to be registered and transparent conditions to be followed once the foreign board of trade is registered. The proposed registration system would replace the existing staff-issued direct access no-action letters traditionally relied upon since 1966 by foreign boards of trade providing direct access from the United States. Many of the requirements and conditions that this proposed rulemaking would apply to registered foreign boards of trade are modeled after requirements and conditions that Commission staff currently applies to foreign boards of trade in our no-action letters. For instance, in determining whether to register a foreign board of trade, the CFTC would evaluate whether the foreign board of trade's home regulatory authority oversees the foreign board of trade in a manner that's comparable to the CFTC's oversight of designated contract markets. I would stress that the operative word here, comparable, is used in both the rulemaking and the Foreign Board of Trade provisions of the Dodd-Frank Act. We would not interpret comparable to mean that the Foreign Board of Trade has to be subject to oversight that is identical to the manner in which the CFTC oversees designated contract markets. Instead, we would propose that the comparability standard mean whether the Foreign Board of Trade's regulator supports and enforces regulatory objectives that are substantially equivalent to those supported and enforced by the CFTC. These objectives would include, for instance, prevention of market abuse, market manipulation, and customer abuse. The proposal describes how and where to apply for regulation and provides a limited registration application process for those foreign boards of trade that are currently relying on the staff-issued direct access no-action letters. The proposal would include in the rule requirements that foreign boards of trade would have to meet in order to be registered. These requirements are divided into the same general categories currently evaluated by staff during the course of a review of an application for no-action relief. They would include membership criteria, the trading system, contracts, settlement and clearing, the regulatory authority, rule and rule enforcement, and information sharing. Whether they are successfully met would be determined by review of the information submitted by the applicant and, as necessary, a staff due diligence visit on site to the Foreign Board of Trade and its regulator. The proposal also details the conditions that a registered Foreign Board of Trade must meet to retain its registration, including general conditions, reporting obligations, and conditions that apply to linked contracts. Staff believes that most of the proposed general conditions and many of the reporting obligations would be met by the Foreign Boards of Trade currently operating pursuant to direct access no action relief. The linked contract conditions include those identified in the Dodd-Frank Act and those derived from Commission staff experience in issuing no action letters. The proposal identifies the types of entities to which a registered Foreign Board of Trade could grant direct access. That includes identified members or other participants in the United States that trade for their own accounts, FCMs that trade for their proprietary accounts or submit orders for customers, and CPOs or CTAs or entities exempt from such registration that submit orders on behalf of U.S. pools or accounts for U.S. customers for which they have discretionary authority. Again, this list of eligible participants is consistent with the existing no action relief. The proposal also identifies certain reasons for which an FBOT's registration could be revoked and identifies certain actions that, if taken by a registered Foreign Board of Trade, could have an adverse impact on the market and the public interest, and the proposal in the preamble sets forth possible Commission actions to remedy such adverse impacts. The proposal describes the procedures to be followed by a registered Foreign Board of Trade that wants to make available for trading by direct access additional contracts not submitted in the original application, including non-narrow-based stock index futures contracts. These provisions are substantially similar to the provisions that a Foreign Board of Trade with a no-action letter complies with today. Finally, the appendix to the proposed regulation identifies what should be included in an application for Foreign Board of Trade registration in order to demonstrate that the registration requirements have been met. The proposed rule would be published for a 60-day comment period. I'd like to take this opportunity to thank my fellow team members for their exceptional efforts in creating what ended up being a very difficult proposal. And finally, I would be happy to answer any questions that you may have, as will David.
Before taking questions, I'd entertain a motion on the staff recommendation.
So moved.
Second.
It being moved and seconded. I want to thank the staff for this. I want to thank my fellow commissioners because it's been I really do say, it's been a pretty active dialogue. This of all 7 of the rules today, but Dwayne, you are not an island. I think that it is important for us to move forward on a registration regime for Foreign Boards of Trade. I think it brings consistency and uniformity to what heretofore has been a no-action process. Started many years ago, done, I think, very well by staff. When I say by staff, by Dwayne. I mean, you don't have a 5-person.
For the last few years, it's been mine.
How many years have you been doing this, Dwayne?
5 or so years, I guess.
But I think that the public, and when I say the public, I mean registrants, as well as the broader public, should have one set of consistent and transparent set of rules as to when we do this. So that's why I'm very supportive. 2 questions came up as this was being pulled together, and I think Dwayne, you and David and others have addressed both of them satisfactorily for me in a proposal. Final rule, just as Commissioner Dunn says all the time, he's going to reserve his vote. This one, I think I don't see where we come out in the final. But one was, how do we deal with current no-action boards of trade, foreign boards of trade, particularly as some of them had modified their no-action letters as recently as maybe 12 or 14 months ago in the case of ICE in Europe, and others or haven't really been relatively looked at in 5, 6, 7 years. And I think the way you address that, which I support, is that you've put a set of conditions that are sort of the most recent. So it is possible that some of those earlier boards of trades will have to look at that. But from what you've said, you think, as I understand, and this is now a question, and then I'm going to go to my second point, is you think that all of the current no-action boards of trade will be able to come into compliance with the futures half of this, and then I'll get to the swaps half.
Well, That actually would be, it's unclear at present because we now have standards for clearing that we have never had before. A clearing organization would either have to register with us as a DCO or comply with the international RCCP standards. And it's unclear to me how many of the clearing entities on these foreign boards of trade with no action letters are in compliance with those standards.
I see, because some of the earlier, smaller ones
Yes.
might not be.
Now, we know that at least two of them are already DCOs. ICE Clear Europe and LCH ClearNet would comply because they're DCOs. We've never asked them to demonstrate compliance with international standards. When we originally started the no action letter program, there were no standards applicable to clearing. In fact, the Commission didn't even regulate clearing entities.
Right.
So
So the first big question was how we adopted them to current standards, and clearing is the best example, and I know Ananda strongly recommended that, but the most recent ones, I support that, but I know that that will be subject to hopefully a significant public comment. The other piece is swaps, and I think that this, and even I was kind of on the fence, as my fellow commissioners know, it is not, I think we're taking the less prescriptive approach, but some might say this is the more prescriptive approach, by allowing foreign boards of trade to also allow swaps to U.S. customers through direct access. I was fearful if we didn't allow that, then all foreign trading platforms would have to be swap execution facilities, and we'd have to, in some other set of rules, or through no action letters, do what is comparable to swap execution facilities. And I support this because this, to me, is a consistent, uniform approach rather than, I was fearful that we'd start using a no action process for swap execution facilities. But I do recognize that including swaps in this is just a proposal, and we really, even I was kind of on the fence on this one. So, but maybe if you want to say anything about the second, wasn't much of a question, but it was a comment. But if you have any comment on the swaps half of this.
We think that foreign boards of trade have traditionally been treated like DCM equivalents, and under Dodd-Frank, DCMs can trade swaps, and we are generally not aware of a reason why a foreign board of trade couldn't also trade swaps. Now, any swaps trading on a foreign board of trade would be subject to membership requirements and all the other requirements that apply to other contracts. All the swaps would have to be cleared. And in addition, we have a couple of additional requirements that are CEF requirements, that is the real-time reporting and reporting of the data to a swap data repository. And we think there are adequate protections for U.S. persons that want to trade swaps through direct access.
I thank you. I too think so, but I could see if people come out the other way. But I would note if we take out swaps from this, I think you have to sort of say then they can't trade swaps, and you have to be a swap execution facility instead. That's why I prefer doing it this way.
We have, despite the fact that we have included swaps, we have included a big comment question at the very end, specifically addressing and requesting comments with respect to that issue.
Commissioner Dunn.
Thank you, Mr. Chairman. Dwayne, as we go forward with this, can we get an assessment of the current FBOTs and whether or not they're in compliance with these 7 general areas that are being proposed?
I could certainly ask for a response once the proposal goes out, but I have no documentation to indicate, for instance, compliance with the new clearing standards, other than the 2 clearing entities that are DCOs. We've not in the past asked for a demonstration that they met any particular standards. We've just reviewed the aspects of the clearing to determine if their risk management and default procedures appeared to provide adequate customer protection.
See what you can provide us. That would be very, very helpful.
Will do.
Mr. Chairman, I guess I would be remiss if I didn't indicate my admiration for your outreach to our fellow regulators around the world and trying to get some consistency as we go forward with this, and our own very overworked international staff does a great job in that area. Again, as we're looking at our resources, Dwayne's not an island. It really is imperative that we understand what's happening here, and we don't end up with regulatory arbitrage as a result of what we're doing. And I am in agreement with what we're proposing here, but I'm also very, very mindful of the job that's in front of us.
I am too. Jackie, I assume you're supporting this one, the head of our international. All right. Commissioner Summers.
Thank you, Mr. Chairman. I think my comments regarding this rule are really with regard to the successful mutual recognition program I think that we have implemented here at the Commission and have had in place for a number of years, where we have a reliance that's built upon these comparable regulatory regimes and our good relationships with our fellow regulators around the world. And although, you know, we may not have looked at some of these exchanges in 5 years, their own regulators have. And this whole system relies on the fact that we trust that their own regulator is comparably and comprehensively regulating them. I was supportive of the provision that was included in Dodd-Frank that basically codified the process that we had had in place by recognizing these exchanges through no action to register these exchanges, because I felt like it was a continuation of a successful program. I think where I come out is I wish that we could have looked at grandfathering these FBOTs that are currently registered. I think it would have been a better use of our resources in this situation, because we have already gone through the process of looking at these exchanges and recognizing them and making the determination that they fall under a comparable, comprehensive supervision and regulation in their own home country. So although I am supportive of the registration process and codifying what we've done instead of having this be under a no action process, I have concerns with regard to the way that this rule is laid out. So I guess I do have a question for Dwayne on the limited registration, and to ask you what, with regard to FBOTs that are currently registered, how that is limited from what a new registrant would have to do.
We would expect that all applicants would have to meet the registration requirements. Now, for a Board of Trade that has an existing no-action letter, we've included a provision that says they can rely on previously submitted documents to demonstrate that they meet certain of the requirements. But we've asked them to provide those documents to us, for one thing, so that we'd have a complete file of all the documentation demonstrating that they comply with the requirement. But since in order for them to meet the limited application requirement, they're going to have to review the document they submitted anyway, I don't see it as a major burden on them to send it on to us. And again, we're going back in some cases to 1999 for documentation, and I'm not sure we would be able to find everything that we need to be able to find that was submitted in 1999.
Actually, just one thing to add, and this also goes to the resource burden. Attendant to one of these grandfather relief filings by an existing FBOT is, once it's before us, they're going to continue to be able to operate pursuant to the no action. So it's going to be seamless as far as their operations are concerned, unlike somebody who's a new FBOT who's going to have to, frankly, wait for their entire application to be processed. So it should be seamless and an easy transition for them to continue their operations.
Thank you.
I just ask, how many foreign boards of trade currently are operating under no action letters?
We have 20 active no-action letters to foreign boards of trade. 14 of them are showing volume from the United States. The other 6 it's difficult to say whether they're actually operating or not. I know they're not here, so they have not been. They are still exchanges, but they're not trading from within the United States anymore, and they have not asked that their letter be removed, and we've not received information from their regulator that they've lost their status as an exchange.
But as far as we know it, though we had issued 20 letters to 20, or we issued letters to 20 exchanges that are maybe still active somewhere, only 14 of them are necessarily active here in the United States at this time.
Now, we've actually issued about 23, 24 letters. 20 of them are still in being. There were a couple of them that were revoked, and one was superseded. 20 are active.
But whether it's the 14 or all 20, what David Van Wagner said is all of them would continue being able to do what they're doing, get us the documentation, as you say, and presumably many of them, maybe all of them, would then be registered as foreign boards of trade. But then on the separate point on swaps, if the final rule includes swaps, they would also be able to offer swaps under certain conditions as long as there's comparable, comprehensive regulation on the 5 or 6 points that are in here.
We would think that they would be able to offer swaps. They would be able to offer swaps once they were fully registered. They have existing no-action letters, and there are no provisions in those no-action letters for swaps contracts. Now, that's not to say they couldn't request an amendment to their no-action letter to trade swaps during the pendency of their registration.
So,
and I don't know how we'd look upon that.
So I thank you for the clarification. So to offer swaps to the U.S. public directly, they'd have to wait for their registration. Yes. But that makes sense. Commissioner Chilton.
Thanks, Mr. Chairman. The only point I wanted to make is that it's one thing just to have U.S. customers, but when they're linked contracts, that raises, I think, a separate level of concern. This dates back to June of 2008 when Senator Durbin introduced legislation, and then Senator Cantwell and others sort of picked up on this issue. And while I didn't have a general problem with what we did as far as the questions we asked for the no-action process, I do think that what ICE did on the WTI lookalike was helpful in agreeing to the position limits for spot month. I think traders were looking at a way to get around the spot month limits in the U.S., and so they went to the lookalike contracts in London. The one question that we are asking here, and I think this is particularly important given what we've learned from the flash crash about the interconnectedness, not of just the futures market and the securities market in the U.S., but of the linkages between global markets. I mean, if the flash crash had happened when the European markets were open, this would have been a problem. So the question we're asking in here, and I hope we get a lot of comments, is whether or not we should require of FBOTs some automatic safety features, whether or not it's price banding or some sort of stop logic-like procedures that pause so you don't have sort of these cascading markets like we saw in the flash crash where folks were arbitraging, in that case between the futures E-mini and other related S&Ps. But in this case, it would be very easy if there weren't similar sort of stop logic measures or circuit breakers, they call them in the securities world, in London. I mean, if you think about it, if the WTI went up or down in a volatile fashion, but then there was a stop logic, but they didn't have that on ICE London, then arbitragers could be going back and forth between the markets. So that's a question we ask here, and I'm hopeful that we strongly consider putting it in sort of one of the requirements. These things we have to remain nimble and sort of quick and looking around the corner at what we're going to have to do in the future. So I agree with Commissioner Summers that this has worked well in the past, but I think we are going to need some tweaks as we go forward, and we need to start thinking about those now, and this is one area that I think deserves real serious consideration. I don't have any questions, though. Thank you.
If not, any comments on that, Commissioner Maya?
I was sitting here thinking about the island that Dwayne may want to be on right now, or what island that he was, and I came up with Vieques, with the bombing range off of Puerto Rico. He's had a long week, for sure. In my short tenure here at the CFTC, it's clear the Commission values its relationship with foreign regulators, and I want to continue to preserve that cooperative working relationship as we go forward. However, I'm concerned that this proposal will cause significant angst among our international regulators and those entities that they regulate. I find myself agreeing with the neutral and straightforward rules, but disagreeing with the overreaching nature of the preamble. This is especially true of the random pre-risk management proposals, which the Commission itself does not even require exchanges in the U.S. to implement. As the chairman of the Technology Advisory Committee, we've conducted 2 meetings in the past 5 months, which address direct market access issues. During the past year, both the FIA and IOSCO have produced proposals on direct market access. This issue is subject to extensive debate. I find the approach used in the rulemaking to be premature, and if we were going to mandate pre-trade functionality, we should take a more thorough review of all the various proposals, including the most recent FIA proposal, which I have right here, which builds on the FIA proposal we heard in our first Technology Committee hearing, and then the IOSCO report of August of 2010. And in addition, obviously, we had some great debate last Friday on the SEC CFTC Joint Advisory Committee, in which they posed a number of very good questions. We do not have solutions yet. And I think before we begin testing concepts in the preamble of the FBOT, I think we should come to some conclusion about these studies and what we're going to do with the SEC CFTC flash crash report. In the brave new world of regulated swaps, harmonization with international regulators is paramount, and the Commission must give adequate consideration and deference to the ability to regulate exchanges within their jurisdiction. I'm eager to hear from our foreign regulators and market participants as to whether or not this rulemaking strikes the right balance. I'm hopeful that the regulators will work together to avoid gaps in the regulatory framework. I will be voting against this proposal, but I did want to ask Dwayne, how are we going to what have you done to evaluate all of these studies that we've conducted so far, and are you waiting? And I know it's a question, and we've adjusted it in the preamble, but are we going to? Don't you think it's appropriate that we get our rules straight here before we test it and impose it on the FBOTs?
Well, I don't think we're actually testing it for the FBOTs, but we realized that the timing is such that this is something that's likely to come up in the DCM rulemaking as well. And DCM being the reference point for the FBOT, registration regime, we thought it would be wise to headline the question, the issue, and base a question upon it for FBOT so that they can think about it. And one thing to point out is that the question that we ask is actually, it pertains to, you're right, these pre-order mechanisms or safety devices. We ask about it in the context only of FBOTs with link contracts, and I would note that, and many of the examples that we throw out are derived from the studies on the May 2010 events. Many of those mechanisms actually are already used by ICE Futures Europe, which really is the only contract, the only foreign board of trade now which has linked contracts. So, we think it is appropriate, and it's unfortunate the timing is such that FBOTs actually comes before DCMs, but we wanted to highlight that this is an issue that we would be thinking, that the Commission might be thinking about.
We did receive specific questions and comment back from both ICE and CME regarding the initial FIA paper as to what they have. If you want a copy of that, I don't know if you saw that in putting this together, and what because it was only a footnote which you've stricken out in the new text. I just want to make sure that we take a very measured approach and we consider it. IOSCO is working towards this. I don't think they have gone to the same level of fidelity and granularity that the FIA papers have. But maybe we ought to have the next TAC committee and move it sooner rather than later to discuss these things. I think this is the first we've seen of it, showing up in the FBOT rule, which I think is premature, clearly. But we should have this discussion. I'm not afraid of the discussion, but I think we should think about it, how we're going to implement it here, and then we have the comparability requirement over on those.
It may be just because my style is always to narrow differences, but what I understand what you're saying, Commissioner, is that the question that now, and it's just a paragraph in the preamble, but it's a question about whether on linked contracts there should be any conditions, or whether the Commission should consider any conditions on those linked contracts about some pre-trade risk. I don't remember what you said. We say in here, but some risk mechanisms about that's the paragraph you're referring to, or at least that you're most specifically referring to.
Yeah, it is. I think before we throw out some concepts like this, I think we're going to raise further concerns among our regulators overseas, because we have a preamble that says one thing, and we have a rule that doesn't have this in it. And I know it's a question now. It wasn't up until we audibled here, which I appreciate, but
it was longer and it was more detailed before.
It's a significant change, and this is the first anybody has seen of this concept in this format. I'm happy to explore. We've had two TAC meetings on it. I don't think we've come to any resolution on it, and I'd like to explore this further about what we're going to implement.
And though we don't have this luxury, I take comfort that you might even support the rule if the preamble weren't there. Right? I mean, the rule. You didn't have a disagreement with the rule. It was the disagreement with the preamble.
It is prescriptive rule. I would be happier not to have the preamble. That's true. That's true.
And could I ask Jackie Mesa, the head of our international affairs, because I know we have shared some of the term sheets and other parts of this with international regulators, particularly in Europe. What have you heard back?
We have received some comments. I think generally, by the way, at international meetings, I've been vocalizing that we have a rule that we're going to form on foreign boards of trade, and I've kind of generally described what it'll look like, although I did not add in the swaps part, as that came later. But people seem generally accepting of the idea that there would be a statutory basis for foreign boards of trade. Second, we did share some term sheets with some regulators and got back a few comments. Most of the comments we tried to actually address as we were writing the rules. There wasn't a great concern. I think they're wondering how we're going to do ongoing compliance with the FBOT. So more explaining rather than the rule itself, just how is it going to work in practice.
Yeah. I mean, I too share Commissioner Summers' view. I think this is an agency that one of its hallmarks has been a strong and constructive mutual recognition program. I think Dodd-Frank adopts that in a sense, and it allows us to recognize if there's comprehensive and comparable and comprehensive regulation of contract markets, swap execution facilities, and clearing organizations. And that's why I was encouraged that we might include swaps in here as well, so that we could get that going. But I do respect that this one's going to be a split vote, and probably more on, as you say, the preamble and some of that, and the grandfathering issue here. I'm sorry, David, did you or Dwayne?
If I could address that one paragraph. We have ICE Futures Europe, which has linked contracts. They're the only exchange, Foreign Board of Trade, that has linked contracts. And through two sets of amendments to their no-action letter, we've imposed at least 9 additional conditions, the first half of which are actually spelled out to be included in the Dodd-Frank Act. We have always provided additional protection for linked contracts because of our obligation to protect traders on the DCM in the United States to which that contract is linked. In this case, the WTI contract traded on NYMEX. It's not unusual at all for us to consider additional conditions for a linked contract. Now, those conditions on ICE Futures Europe apply specifically to those contracts, not other contracts that are not linked.
I'm not taking issue with the requirements. I'm just taking issue with the way we're rolling this out in the venue. We're testing a theory and some ideas on which we haven't even applied our own standards on. So if you want to go through all of this and go through the specific recommendations and test them out, that's one thing. But we just threw some ideas out there and said, what do you think? Are we going to apply the fat finger and the kill switch and some of these other things that are well thought out in these documents, but we haven't done that here. And that's the problem I have with this.
I mean, we do have fat finger. We do have stop logic in our markets already. Is there something else, Commissioner O'Malley, that's separate than that you're concerned about?
No, I am not at all concerned with the specific controls and the pre-trade risk functionality. That's what we had the debate about in the two TAC committees. I have concerns with how we're rolling them out and what certainty we're giving to the market and our international regulators overseas about what we're doing. This is not a thorough discussion by any means about which activities we're going to apply and not apply, or which we favor and we don't favor. Let's go through it. Let's have the debate, and let's be specific about which controls we favor and do not favor. Absolutely, I agree. I disagree with the FIA and the wash sales.
Yeah.
It's not the controls that I have a problem with. It's the manner in which we're launching this in a preamble on a new rule.
Yeah, I mean, my preference actually would be to put it in the rule, because I think that these are things that we absolutely need. I think the flash crash told us that we're going to have arbitrage opportunities. So, but I sort of thought that, and maybe the preamble isn't the right place. Maybe just a question would have been better. But I agree with you that we need to have this debated, and we want people to comment. But if we don't ask, they won't tell, and that's why I'd like to have it out there. Maybe the preamble's not the right place, but it's better than nothing.
If I could just comment, I think that these issues are extremely complicated and are issues that that market participants in the industry have been concerned about for a number of different years. They've come up with some of these best practices which we have discussed, but we haven't settled on where we think our own markets should be in the United States. So I don't disagree that it's something that we should put a lot of thought into and in what we impose on our own markets and on our registrants. But it's not simple, and I think that whatever we end up doing here, then we can decide whether or not it's appropriate for conditions to impose on an FBOT.
But by virtue of having the comparable language, if we adopted it here, we could assume it would be adopted over there. Is that correct? I'd ask the council.
David?
Yeah, if it was adopted across the board, right, for all DCM contracts, that's correct. We would probably look for something that would be similar on FBOTs.
David, and just on this narrow question, because there's a lot of other pages, but on this narrow question, if it were adopted, and we don't even know if we would, but if we were to adopt on contract markets and swap execution facilities some pre-trade risk management functionality, you're saying we could then subsequently ask, this could be 2 years from now, but ask the then registered foreign boards of trade to come into compliance with that feature? Sure. On the linked contracts? I'm sorry, on the linked contracts?
Right. Well, actually, it would be even more extensive than the linked contracts, obviously. If you applied it to DCMs on all their contracts, then I think that we would look for similar mechanisms on FBOTs for all their contracts. But, yeah, I mean, you have to keep in mind, comparable, comprehensive means that you're always looking to a reference point, and the reference point is what's applicable to DCMs. So to the extent that the requirements for DCMs increase, change, decrease, then there would be a knock-on effect for FBOTs.
Well, I think in that case, that's a little bit further than I guess I thought it went. In that case, I would suggest that we need to take this discussion up in IOSCO. We can't ask for comparable regulation from our international counterparts if they haven't had the opportunity to approve this in their own regulatory authorities. Jackie, do you?
IOSCO did just publish a report on direct electronic access with a number of high-level principles that regulators should look for market integrity purposes, and perhaps the best way to go forward, one suggestion would be to reference that report, which we accepted at the CFTC and adopted, and other regulators did as well.
But is it this specific?
It's not this specific.
I guess to follow up, do you think that IOSCO will, in the future, consider pre-trade risk controls that may get more specific than what we've done with the direct market access paper?
I don't know. As I talk about the specificity of that report, the principles themselves are not specific, but the body of the report goes into more detail on options. It's more of an optionality of things that you could apply to the market. So whether it says you have to do X, Y, and Z, I don't think IOSCO will probably go in that direction as much as give a range of options that get you to the same point.
Commissioner May?
I have one question. The other part of this is the May 6th. And remind me, Mr. Chairman, what our timetable is to have those recommendations, because I think it references May 6th right here. It references our May 6th, one of our May 6th reports, our May 18 report, in our footnote in this new amendment. How does this, how should international regulators read that? Maybe I should. That's a better question, not you, Mr. Chairman. I apologize. But how did
I'll take the question.
May 18? We referenced the May 18 Joint Committee. There are no recommendations.
No, I mean, actually, the reference there is to basically indicate that some of these mechanisms are actually discussed there, and also, actually, if anybody takes the trouble to look, they'll see that many of these mechanisms are in place already at ICE Futures Europe as well as CME. So that was the point of the reference.
Okay. Fair enough. So out of that, we're going to get recommendations from the committee, the advisory committee, shortly, I see.
Yeah, we've asked them in January, but, they're human, too.
Oh, absolutely.
I asked them for January.
I understand. I just want to understand what we're asking, what international regulators and registrants, whoever these are, should understand what we're dealing with here. And I think the process is important to understand what the other reforms might be out there.
I mean, the positive part of this debate, even here, is we're going to get comments on this paragraph. It could be called the discussion paragraph. I won't name it anything. And it's just a paragraph, by the way, for the press asking about whether there's additional conditions on linked contracts for these pre-trade risk functionalities. And I encourage the public to comment, but we're going to have comments from the advisory committee. Hopefully in January, we'll have comments from your TAC, the advisory committee. This is just a proposal in any event, and this is a question in the preamble, not in the rule. But I think with that, maybe I'll call the vote. All those in favor of sending the Foreign Board of Trade rule to the Federal Register, say aye.
Aye.
Aye. Any opposed?
Opposed.
I don't know if I heard from Commissioner Chilton. You might be the swing vote, my friend.
The reluctant aye.
Yeah. So it's 3-2 to at least send it to the Federal Register. What I normally do about here, other than thanking the staff, is see whether I also have to have a vote on any technical corrections, because I seem to have done that every week. And do I? So there is I ask for a motion. Oh gosh, I ask for a motion at this point for unanimous consent to allow staff to make technical corrections to the documents voted on today prior to sending the Federal Register.
So moved.
Second.
All those in favor?
Aye.
It says here chorus of ayes. So I want to really thank everybody. I mean, this is this is 7 rules in one day. We do meet on November 19th, which I guess is next Friday. We'll publish in the Federal Register on, I guess, or on our website, I guess, more technically on the website, and maybe the register on Friday, the topics. I do fear, Commissioner Malia, just as some of the staff work over here, I think real-time reporting is for that day, and it's partly because we're aligning with the SEC, but we'll keep talking about that one.
Any chance we can get definitions moved up? I'm ready to work.
I am too. Right now, it looks like it's calendared for December 1st, but maybe entities and products is a little, it's just maybe both. But with that, is there any other commission business? If not, I will entertain a motion to adjourn the meeting.
So moved.
Second.
All in favor?
Aye.
Good, unanimous. There we go. Thank you.